सॉरी, मैं अश्विनी जिंदल चार्टर्ड अकाउंटेंट एसोसिएशन की तरफ से और जीएसटी एंड टैक्सेशन बार की तरफ से आप सबका स्वागत करता हूं। ये जो हम 6 डेज का जीएसटी के ऊपर सर्टिफिकेशन कोर्स कर रहे हैं, इसमें मैं ऑलरेडी आपको बता चुका हूं कि इट इज ए मिक्सचर ऑफ टॉपिक्स, क्रिटिकल टॉपिक्स एज वेल एज इंडस्ट्री वाइज। हमारे पहले 2 सेशन में ऑलरेडी हम आईटीसी और डिपार्टमेंटल ऑडिट, रादर डिपार्टमेंटल ऑडिट में जो हमारे कल के स्पीकर थे सिद्धार्थ पाठक जी, उन्होंने काफी टॉपिक, चाहे वो इंडस्ट्री के रिलेटेड थे या जनरल थे, सारी चीजें उन्होंने कवर कर दी डिपार्टमेंटल ऑडिट के माध्यम से कि डिपार्टमेंट चेक क्या क्या करता है जब ऑडिट करने आता है। लेकिन फिर भी हमने स्पेसिफिकली टॉपिक रखे हुए हैं, टॉपिक वाइज भी और इंडस्ट्री वाइज भी, जिसमें डिटेल में आपको एलेबोरेट करेंगी हमारी फैकल्टीज। आई वेलकम आवर टुडेज फैकल्टी सीए एडवोकेट संदीप गोयल जी। वो चार्टर्ड अकाउंटेंट भी हैं, एडवोकेट भी हैं, एंड ही इज प्रैक्टिसिंग इन पंजाब हरियाणा हाई कोर्ट। जैसे पीयूष जी ने मेरे को बताया कि लिटिगेशन मैटर में जो हमारे मास्टर हैं, जितनी भी हमारी लिटिगेशन है अरेस्ट केसेस के रिलेटेड जहाँ एससीएन के रिलेटेड, तो आज ये आपको संदीप जी उसके बारे में बताएंगे कि क्या हमारे राइट्स हैं, क्या ऑब्लिगेशंस हैं, क्या सारी इन चीज़ों के बारे में डिस्कस करेंगे। तो मैं ज़्यादा वक्त ना लेते हुए रिक्वेस्ट करूंगा पीयूष जी को, जैसे मैंने पहले अनाउंस किया था, एक चीज मैं दोबारा रिपीट करना चाहूंगा क्योंकि बाद में भी कोई यूट्यूब वीडियो सुनता है, कि सर्टिफिकेट हम उन्हीं को प्रोवाइड करेंगे जो कम से कम 6 दिनों में से कंप्लीट 5 डेज अटेंड करेंगे। राइडर इज 5 डेज एंड 10 आवर्स, ये होने चाहिए आपके, तभी सर्टिफिकेट प्रोवाइड करेंगे। अदरवाइज हम इसका सर्टिफिकेट आपको अटेंडेंस का नहीं देंगे। लेकिन आप इसकी लर्निंग हमेशा ही ले सकते हो, क्योंकि 90% हमारे प्रोग्राम लर्निंग के लिए ही होते हैं। तो लर्निंग आप हमेशा हमारे माध्यम से कर सकते हो, चाहे वो यूट्यूब के माध्यम से करो, चाहे लाइव माध्यम से करो, लेकिन सर्टिफिकेट तभी मिलेगा जब आप सिंसियरली अटेंड करोगे एटलीस्ट 5 डेज फुल। थैंक यू वेरी मच। आई रिक्वेस्ट पीयूष जी टू फर्दर इंट्रोड्यूस दी स्पीकर एज वेल एज डिटेल्ड टॉपिक जो आज वो कवर करने जा रहे हैं।
Thank you, Ashwini ji. Thank you very much. First of all, I would like to welcome CA Advocate Sandeep Goyal ji, a very good friend of mine. उनको एक सिंपल सी रिक्वेस्ट की कि सर आपका टाइम चाहिए। He said Saturday है तो कोई दिक्कत नहीं, फिर उस दिन कोर्ट से ऑफ है, मैनेज हो जाएगा। आज क्योंकि इनकी लाइन मेनली मेरे हिसाब से ये रहती है, तो मैंने इनको रिक्वेस्ट की कि आप नोटिस, शो कॉज नोटिस एंड लिटिगेशन को डील कीजिए। और सबसे ज्यादा इशू रहते हैं रियल एस्टेट एंड कंस्ट्रक्शन में। तो ये रियल एस्टेट और कंस्ट्रक्शन जो हमारी इंडस्ट्री टॉपिक है वो भी कवर कर रहे हैं, और शो कॉज नोटिस एंड लिटिगेशंस ये पार्ट संदीप जी कवर करेंगे। संदीप जी का मैं तारुफ आप सबसे करवाना चाहूंगा। संदीप जी लॉ ग्रेजुएट है पंजाब यूनिवर्सिटी से एंड एट द सेम टाइम चार्टर्ड अकाउंटेंट है, मेरे से 6 महीने सीनियर है। 99 नवंबर अटेम्प्ट में ये क्वालिफाई हुए हैं और प्रैक्टिस करते हैं पंजाब हरियाणा हाई कोर्ट में। बहुत ही ज्यादा सीजन्ड एडवोकेट लॉयर हैं ये। सुप्रीम कोर्ट में भी अपीयर हुए हैं, पंजाब हरियाणा हाई कोर्ट, हिमाचल प्रदेश हाई कोर्ट, गुजरात हाई कोर्ट, वैट ट्रिब्यूनल, वैट और सेल टैक्स में। अगर आप लोगों को याद हो, जब हम वैट में डील करते थे तो जो हमारे टैक्स मैगजीन्स आती थी जिसमें केसेस पब्लिश होते थे, उनमें से मैक्सिमम केसेस हमें संदीप जी के या इनके फादर साहब कृष्ण गोयल जी के मिलते थे। तो वो सबसे ज्यादा केसेस डील इनके होते थे और पब्लिश भी इनके होते थे। मतलब आज तक संदीप जी की 1000 से ज्यादा जजमेंट्स हो चुकी हैं, जो रिपोर्टेड या अनरिपोर्टेड टोटल मिला के बहुत ही बढ़िया तरीके से डील करते हैं। अभी रिसेंटली जो लैंड मार्क जजमेंट हुई है शिव एंटरप्राइजेस वर्सेस स्टेट ऑफ पंजाब की 2022 की पंजाब हरियाणा हाई कोर्ट की जजमेंट है, जहां पे कोर्ट ने पावर्स ऑफ ऑफिसर, जो गुड्स इन ट्रांजिट्स को रोकने की पावर है, उनकी पावर क्या है ऑफिसर्स की, वो सारी इलेबोरेट की है। वो भी संदीप जी का ही केस है, ये रिसेंट 2022 का ही केस है। ऐसे कितने ही लैंडमार्क जजमेंट्स हैं इनकी, और इनकी क्लाइंट लिस्ट में तो जितने बड़े नाम है, चाहे रिलायंस है, हीरो है, अडानी है, अंबानी है, सभी इनकी क्लाइंट लिस्ट में है। बुक पब्लिश हो चुकी है इनकी 75 लैंडमार्क जजमेंट्स अंडर जीएसटी लॉ। और ये जो हमारा टैक्स मैगजीन आता है जीएसटी पे, हरियाणा वैल्यू एडेड टैक्स का, उस पे, और ये करनाल से पब्लिश होता है जीएसटी का, उसके ये वो भी है, क्या कहते हैं उनको, एडिटर, ऑलरेडी एडिटर हैं ये, इतनी ज्यादा रिनाउंड पर्सनैलिटी को आज हमने रिक्वेस्ट की है, एंड आई एम वेरी मच थैंकफुल वंस अगेन संदीप जी फॉर योर काइंड प्रेजेंस, एंड नाउ आई रिक्वेस्ट यू टू स्टार्ट योर डेलिब्रेशन सर।
थैंक यू पीयूष जी, आपने जो बातें कही हैं उनको सुन के बहुत अच्छा लगा है। कई बार हम भी भूल जाते हैं कि हमने ये कुछ कर लिया है, बट आपने एक बार रिवाइज करवा दिया सारा, तो बहुत अच्छा लगा हमें भी सुन के कि हमने इतना कार्य कर लिया। पर ये सब आप लोगों के भाइयों के सहयोग से ही पॉसिबल हो पाता है।
सर आपकी अचीवमेंट पे हमें खुशी होती है, वी फील प्राउड अबाउट दैट।
एब्सोल्युटली एब्सोल्युटली, ये सब लोगों का म्यूचुअल होता है। वी फील प्राउड ऑफ यू। सो anyways, thank you so much, the organization, the voice of CA, C Ashwini Jindal ji, and all the other office bearers of this organization who have took up this initiative and have taken up this certificate course for the chartered accountants. And I think it's quite fruitful, as he has already told in the beginning that कल ऑडिट के ऊपर हुआ था, उससे पहले अशोक बत्रा जी भी यहाँ पर डेलिब्रेट करके गए हैं। तो आपके प्लेटफॉर्म के ऊपर I think one of the most renowned experts in the GST law, they have already come and deliberated. So I'm sure it is going to be of much this is going to be of helpful to all the chartered accountants who are hearing and listening to these lectures. आज के टॉपिक पे हम लोग आते हैं. So I want to make it little interactive session rather than I am speaking from one side. So I would request, in case आप लोग थोड़ा सा इंटरेक्ट करेंगे हमारे साथ, तो that will be much better. चैट बॉक्स के अंदर आपका
एक मिनट सर, चैट बॉक्स मेरे ख्याल में कहीं को दिक्कत आती है, ओपन कर दूं। वैसे तो क्यूए तो ओपन ही है,
Q&A में कर सकते हैं।
Q&A ओपन है, मैं वो भी कर रहा हूँ सर। एक मिनट, अटेंडिंग कैन विद द होस्ट सर, ये भी मैंने कर दिया, चैट बॉक्स भी ओपन। और मेरी एक रिक्वेस्ट भी है आपसे, रादर मतलब कहते हैं आई फील सॉरी कि आज पीयूष जी ने भी किसी फंक्शन में जाना है, मैं भी फगवाड़ा जाना है, तो आज मैं आपको भी रिक्वेस्ट करूंगा कि आधा घंटा पहले काइंडली अगर आप क्लोज कर देंगे 5:30 पे, तो इट विल बी नाइस, क्योंकि पहले तो मैंने इनको 5 का कमिट किया था, अब मैं 5:30 पे चलूंगा जी यहाँ से।
कोई बात नहीं सर, हम कोशिश करते हैं जितनी जल्दी हम इसको सम अप कर पाए इस सारे इश्यूज को। हालांकि टॉपिक बहुत वाइड है, बट हम कोशिश करेंगे।
नहीं सर, अदरवाइज नो प्रॉब्लम। मेरे एक वो है, अभी फोन नहीं उठा रहे, गौरव गुप्ता जी, अदरवाइज अगर वो आते हैं ही विल मॉडरेट टिल 6, अगर वो आ जाते हैं तो देन वी विल कंटिन्यू टिल 6।
नो प्रॉब्लम अश्विनी जी, विल कैरी ऑन, डोंट वरी। तो फ्रेंड्स, जो आज का इशू हम लोग, आज का जो टॉपिक हम टेकअप कर रहे हैं, दैट इज पर्टेनिंग टू द लिटिगेशन, शो कॉज नोटिसेस एंड नोटिसेस, एंड ऑफ कोर्स अ सेकेंडरी इशू व्हिच इज इन द शेप ऑफ द इंडस्ट्री स्पेसिफिक इशू इज द रियल एस्टेट सेक्टर। तो पहले हम लिटिगेशन की बात करें। स्पीकिंग फॉर पर्सनली फॉर माई सेल्फ, आई वुड से कि लिटिगेशन से हमें तो प्यार है। मैंने जब सीए की प्रैक्टिस शुरू करी थी आफ्टर क्वालिफाइंग एज अ चार्टर्ड अकाउंटेंट, which is of course one of the most difficult examination in the country, I would say the most difficult examination in the country.
सर
तो
उसके बाद सब डिफिकल्ट एग्जाम हमारे लिए था, आप तो 45 रैंक होल्डर हैं सर।
चलिए, हमारे ऊपर अभी भी 44 लोग थे, ऐसी बात नहीं है। तो ऐसे है कि वो एग्जामिनेशन जब हमने क्वालिफाई करा तो सब लोगों ने कहा कि आपने सीए का एग्जाम क्वालिफाई करा है, तो इट्स वन ऑफ द मोस्ट प्रेस्टिजियस डिग्रीज, तो आप सीए की ही प्रैक्टिस करिए। तो हमने सीए की प्रैक्टिस शुरू करी थी। बट लेट मी टेल यू कि लिटिगेशन, क्योंकि मैं फादर साहब के साथ व्हेन आई वाज स्टडीइंग, तो आई यूज्ड टू गो विद हिम टू द कोर्ट्स। सो इट्स अ काइंड ऑफ माय फैसिनेशन, आई यूज्ड टू गेट फैसिनेटेड विद द कोर्ट रूम विट्स, I used to get fascinated with the kind of deliberations which are made and the results which would come. तो जैसे ही थोड़ा थोड़ा टाइम निकला तो मुझे लगा कि मेरे को अपना जो एक गोल है वो लिटिगेशन की तरफ ही परस्यू करना चाहिए, which is of course going to be much satisfying for me. तो जीएसटी जब आया है तो जीएसटी में लिटिगेशन की भरमार हो गई है। कुछ लोग मेरे पास आते हैं, टैक्स एडवोकेट्स खास तौर पे मेरे साथ जब भी बात होती है, तो एक ही इशू आता है उनका कि जीएसटी के बाद काम कम हो गया है। उसके अंदर जो पहले सिस्टम होता था कि असेसमेंट्स नहीं है, ऑफिसर्स के पास जाना है, असेसमेंट्स करवानी है, वो सारे का सारा इशू अब आज की डेट में नहीं होता है। तो किसी ना किसी तरीके से उनको लग रहा है कि हमारा काम कम हो रहा है। तो मैं एक ही बात कहता हूं कि आप थोड़ी देर वेट करिए, लिटिगेशन जो है वो इंक्रीज होने वाली है, एंड दैट इज गोइंग टू इंक्रीज मैनी फोल्ड। 2017 में जीएसटी आया, उस टाइम पर हमसे बड़े बड़े वादे करे गए कि जीएसटी इज गोइंग टू बी गुड एंड सिंपल टैक्स, कोई भी बच्चा इनकम टैक्स की रिटर्न भर सकता है, एंड सो फोर्थ, वन नेशन वन टैक्स, सीमलेस आईटीसी एंड सो मेनी थिंग्स, कि आपको कुछ भी नहीं प्रॉब्लम आएगी, अगर आपसे शुरू में कोई गलती भी होगी हम आपको छेड़ेंगे नहीं। जैसे जैसे टाइम बीतता गया, इश्यूज अराइज होने शुरू हो गए, लिटिगेशन अराइज होनी शुरू हो गई। सबसे पहले लिटिगेशन जो इस इशू जीएसटी के अंदर आई थी वो आई थी ट्रेन 1 की। जब लोगों ने शुरू में ही ट्रेन 1, उनका टाइम निकल गया, या ट्रेन 1 भरने में दिक्कतें आई, या उनके फॉर्म समझने में दिक्कत आई, या किसी ने एसजीएसटी का सीजीएसटी में डाल दिया और सीजीएसटी का एसजीएसटी में डाल दिया, तो इवेंचुअली हुआ क्या कि लिटिगेशन वहां से स्टार्ट हो गई। और डिपार्टमेंट का एटीट्यूड जो था एज यूजुअल वाज ऑफ कंप्लीट एडमेंसी। दे वर सेइंग कि हम आपको कोई भी किसी तरीके से रिलीफ देने को तैयार नहीं है, क्योंकि आपका एक बार टाइम निकल गया तो निकल गया, हम आपको आईटीसी नहीं देंगे। पीपल वर क्राइंग बिफोर देम कि जी ये तो हमारा वेस्टेड राइट है, हमारे पास आईटीसी हमारे पास वैट के अंदर या हमारा सेंट्रल एक्साइज के अंदर हमारे पास पड़ा हुआ है। हाउ कैन यू सिंपली डिनाई इट बाय सिंपली फॉर द सेइंग कि हमारी वेबसाइट के ऊपर 27/12/2017 के बाद आप फॉर्म फिल नहीं कर सकते हो। लोगों के करोड़ों रुपए इन्वॉल्व थे। Anyways, that litigation was pursued. We succeeded.
Sir, there is one request from participant that some of them are from South India, not knowing Hindi.
All right, sir. All right. I was mixing Hindi and English simply.
Yeah, that is great, sir.
That is always great.
Because I normally get a request that I should be speaking in Hindi and English mix so that everybody can understand. But nevertheless, we will try.
That will be always.
Ji. All right. All right. I've got the message. So we will try and mix up Hindi and English. All right. So friends, the first litigation, as I was talking about, was on the question of Train 1, which we fought, and we fought hard in the courts. And eventually, Punjab Haryana High Court had given a very detailed judgment in the case of Advert Technologies in favor of the assessees, keeping in view the fact that one, this is a vested right, and secondly, the GST system, the portal was not working properly, so it's in the ambit of equitable jurisdiction of the High Court that such a relief should be granted, and eventually it was granted. So still the department was showed a lot of stubbornness, and they had gone to Supreme Court by challenging that order. At first the SLP was dismissed, but in the other matters the stay had been granted. Fortunately for us, better senses prevailed upon the government, and very recently in the case of Philco, they have given a statement before the Supreme Court, which has been incorporated in the order, that the Tran 1 benefit would be given to all those assessees who still want to file it, and that time has been extended up to 30th of November. So that was our first, I would say the first encounter with the litigation under the GST before the High Courts. As the time traveled, so we have now come across multiple litigations arising out of GST laws, the implementation of those laws, and more of, I would say, the most of that litigation can be easily avoided if the department is little cautious and is little cooperative with the assessees. Nevertheless, for we professionals, we have to come to their savior, and we are trying our best for that purpose. So litigation, I would say, would encompass few things. One, the litigation would be relating to the inquiry which is being made from the assessees. Inquiry in the sense that summons are being issued, the notices are being issued to provide some information, and all those the assessees are being asked to furnish information under Section 151 and all those things. And then second could be the second stage of the litigation could be the show cause notice, which we normally encounter under Section 73, 74. Not to talk about the notices which are issued to us under ASMT 10 while the scrutinized returns are scrutinized, and thereafter in certain cases the audit also takes place. Then the third kind of litigation would be the coercive steps which are taken by the department. We will be deliberating all these coercive steps a little later, but there are 5 types of coercive actions which can be taken by the department, and thereafter the litigation has to be taken up before the different forums. When we talk about the forums, or when we talk about the authorities where such litigation would happen, so there are 5 places where the litigation would be taken up. One, the departmental authorities, where we contest the show cause notices, or certain notices, the other notices are contested, not only show cause notice, the other notices are also contested. Second forum would be the first appellate authority, which are normally in the rank of additional commissioner or the commissioners. Then the third category of the litigation forum would be the tribunal, which unfortunately has not been constituted despite passage of 5 years. And very recently, the department has come out with a statement, the Revenue Secretary has come out with a statement that don't worry, we are going to have a tribunal by the end of December 23. तो 1 साल के लिए उन्होंने adjournment already दे दी है कि 1 साल अब बोलना मत, हमने बोल दिया आपको December 23 the tribunal would be constituted. Then the next forum of litigation is the High Court, which at present I would be saying is dealing with most of the highly explosive litigations under the GST. Then, of course, the last and final forum is the Supreme Court, where the matters travel normally on the constitutional issues. At present, the litigation issues which are arising, which are pending before the courts. So I'll just take up one by one some of those litigation issues. Of course, this is not an exhaustive list, but this is of much importance, which is probably relevant for all of the tax professionals. Friends, जो सबसे important and सबसे prevalent litigation which is going on in the country is relating to the ITC rejection. Not going into the issues of merits of whether the ITC should be granted or not, but this is one of the most litigative area. The assessees are claiming the input tax credit, and the departments comes out with some sort of inquiry or some kind of information that the input tax credit which has been taken by you is not correct, as the predecessor has not paid the tax, or the predecessor of the predecessor has not paid the tax. In such a scenario, they go on to say that as per our provisions of section 16, you are not entitled for the input tax credit as the tax has not been paid at any of these stages. Now, this is one of the issues which had actually cropped up not only in the GST, but had been going on for quite some time, and was also one of the most litigative issues under the VAT Act as well. Under the VAT Act, there was the first judgment which had come in the country, which was on a positive side, was in the case of Gherulal Balchand by Punjab and Haryana High Court. In that case, we were the counsels in that, so we had challenged the vires of Section 8 of Haryana VAT Act, saying that in case a person has a genuine transaction, he cannot be denied the input tax credit merely on the ground that his predecessor seller has not paid the tax on that transaction. If that is going to be the scenario, it is almost impossible for me to implement, to follow that law or to comply with the provisions of law. I, as a buyer, cannot ensure that my seller would be paying this tax or he has paid the tax. There is no machinery with me either to force him or to even check as to whether he has paid the tax or not. So this litigation, when it was taken up before the Honorable High Court, one of the examples which we had taken is, which we put to the Honorable Court itself, that suppose a person who has bought a car worth rupees 10 lakhs of rupees, अब वो 10 लाख रुपए की कार लेके आया है, he goes to market, he goes to one of the reputed shops, the car automobile dealer, he buys the car, he pays the tax, he pays everything by check, he comes back, coming very happily to his home with the family to celebrate the car. Piche uske, some of the officers follow him and come to his house and say, look, Mr. Goyal, you have bought this car worth rupees 10 lakh on which the tax was to be paid 1 lakh. But look, you might have paid 11 lakhs to the seller, but he has not paid the tax. Now you pay 1 lakh rupees more. So I would be completely shocked. I will have no answer that how can I be fastened with the liability of a person who has defaulted. In case he has defaulted with the payment of tax, he should be punished. High Court had accepted our argument. High Court had readily agreed that yes, you cannot be asked under the law to do a task which is impossible to be performed. Therefore, the court had struck down, or not struck down, I would say, read down the provisions of Section 8 of the Haryana VAT Act to mean that ITC would be available to you provided there is no fraudulent intention or there is no fraudulent transaction, irrespective of the fact whether the seller has paid that tax or not. So in case you have a genuine transaction and you are able to establish that, or vice versa, the department is not in a position to establish that there is any fraudulent transaction, then in that scenario, the ITC has to be provided or has to be passed on. This issue had later on cropped up in many high courts, in the Delhi High Court in the case of Shanti Kiran, and thereafter in the case of Arise India, and so many other high courts across the country. All those courts had accepted the view taken by Punjab and Haryana High Court and allowed the input tax credit, provided, of course, the transaction in question is not a fraudulent one, barring one judgment of Honorable Madras or Honorable Bombay High Court in the case of Mahalakshmi Cotton, where a contrary view had been taken. SLP against Mahalakshmi had also been dismissed, and SLP against the orders of other High Court like Delhi High Court had also been dismissed. So there is no finality of law on this issue from Supreme Court. But yes, Punjab and Haryana High Court and various other high courts have taken a consistent view of granting the benefits to the SSC. So carrying on that logic or carrying on that judgment in the regime of GST, the same argument has been raised by us in various courts where we have challenged the violation of section 16(2)(c), which is the section which has been relied upon by the department to say that ITC would be denied to you since no tax has been paid. Now, that litigation, of course, is pending before the various high courts, and I think relying upon the earlier judgments and relying upon the same logic, we may be able to get through on that issue. But this is one of the most litigative issues which we are all encountering. I would be taking up how do we handle this when we take up the topic of input tax credit, or on the topic of show cause notice, how to handle that. दोस्तों दूसरी जो एक litigation which is going on for quite a while, I would say it began immediately after the GST Act had been implemented in 2017, or I would say in 2018 rather, Aap and Company pertaining to section 16(4). That was one of the most interesting litigation which I have come across, and I must commend the efforts made by the lawyers in the case of Aap and Company, who had taken up that argument and had got through with that argument before the Honorable Gujarat High Court. Of course, the luck did not favor them in Supreme Court, but nevertheless, that was a point which was worth discussion. And I would say I still have a belief that the point taken by them was absolutely correct. Friends, some of us would presume that after the judgment of Bharti Airtel, whereby the Aap and Company had been overruled and Aap and Company itself having been reversed, probably the issue has now become academic and it is dead. So therefore, you cannot get an input tax credit in case you have claimed that in the returns GST or 3B, which have been filed after 20th of October for a particular year, in case it belongs to the earlier period or the earlier financial year. To my mind, this issue is still alive and can be very well litigated before the courts. I'll tell you how do we do, how can we do that. Friends, we would recall that there was an amendment under under Rule 61, which prescribes the returns to be filed under section 39. Now, as per section 39, the rules can prescribe the filing of a return, which would incorporate not only the payment of tax, but also the details of sales, details of purchases, details of input tax credit, details of RCM, so on and so forth. This is incorporated in the section itself. Now, when we travel to Rule 61, if you have a look at the original Rule 61, Form GST 3 has been prescribed, which was the correct return in the first place, which unfortunately could not be implemented. But while amending Rule 61 for the purpose of 3B, they have forgotten that Form 3B return does not incorporate all the details which are required as per Section 39. I'll rephrase it. Section 61 says that the rules can prescribe the filing of a return which would have certain particular information like sales, purchases, ITC, payment of tax, RCM, etc. But Rule 61, which prescribes 3B and Return 3B, does not contain the information pertaining to your purchases. I hope I'm correct. Form 3B does not contain the information pertaining to the purchases which have been made by you. It talks about the information pertaining to your ITC, but does not talk about the detailed information of purchases which have been made by you. So in that scenario, I would be saying that amended Rule 61 does not contain the information as required under this section, and therefore that rule would be violative of original provision and has to be struck down. In that regard, the litigation is already pending before the Punjab Haryana High Court. Having said so, to buttress my argument, I will illustrate you one more thing out of the Act. Friends, as per Section 54, we can seek refund of the amount which has been paid by you. And there are two types of refunds which we normally get. One is the refund of the ITC which has been paid by us in the situation of export or in the situation where there is an inverted duty structure. Then there is another refund of cash ledger which we can obtain. Can anybody share with me as to how do we get refund of the amount lying in cash ledger these days? Can anybody answer on the chat? Actually, chat is open or not?
जी open, QA भी open है, chat भी open है. QA में originally it was
all right. Devinder ji has replied. Originally it was Form 3. No, how do we actually do these days? How do we get the refund of amount lying in cash ledger? What's the procedure which we adopt normally? All right. So we all apply in RFD 01. We all apply in RFD 01. Mr. Devinder Singh is absolutely correct. While we apply in RFD 01, is it correct? It is not. As he has rightly put it, under Section 54(1) proviso, it has been provided that you can claim the refund of the excess lying in your cash ledger while filing a return prescribed under Section 39. Kindly read it. I'll rephrase it again. You can obtain the refund of the amount while filing a return prescribed under Section 39(1). So if you are filing a return prescribed under Section 39(1), that return has to have a column pertaining to the refund of excess cash ledger, which unfortunately 3B does not have, and GSTR 3 did have, meaning thereby that GSTR 3B is not complying with the provisions of the Act. And any attempt made by this legislature to make 3B as a statutory return is of course not as per the provisions of the Act. So therefore, the litigation we can still take up before the different courts. And fortunately for us, let me tell you, in the judgment of Bharti Airtel, which was a very drastic judgment otherwise, this issue has been specifically taken up that the vires of Rule 61 have not been challenged. Because in that case, the circular had been challenged. But where we are going to challenge the vires of Rule 61, I think we still have very good ground to take it up and succeed. So the issue with regard to 16(4) and Rule 61 is not dead as yet. So in case we are advising our clients that they cannot take the credit, I would advise that they should litigate. Of course, depending upon the volumes involved, we have to take up those issues before the different high courts. wherever it is, wherever the assessee is there. Then friends, the third type of litigation which we are facing these days is a payment, forceful payment, which is taken by the department either during the search or while you have been summoned under section 70, where they force you to make payment. And how do they do it? They simply ask you to fill a form DRC03, where the payment is taken either from your credit ledger or it is taken from your cash ledger. So this DRC03 has become a kind of, I would say, routine for the department. Now the assessee wants to say that you have recovered the amount, or where is the adjudication of the issues? Somebody would simply come and say that your ITC is incorrect. You are not entitled to take this input tax credit. And without any adjudication, without any show cause, without any reply from me, without any following the procedures of natural justice, you would simply prosecute me, simply take that amount and would not allow me the opportunity to take it, seek refund of that amount. So this was quite prevalent, right, initially, and it is going on even now when the people are threatened with arrest and certain other coercive steps, they end up paying this amount. We have been litigating this for the last 4 or 5 years. In some of the cases, of course, we have succeeded. The courts have taken a view that one, you cannot have any forceful recovery. You cannot have the forceful recovery from the assessees. And secondly, in case the recovery has been made, at the best, you can retain 10% of the tax amount. The remaining amount you have to refund. But depending upon different cases, the litigation is still pending, because in certain cases, the department is pleading that, yes, it's a voluntary payment and we have no role to play. I go a step further. Let us assume you have made the payment in DRC03. That would be, of course, under as per Rule 142. And department claims that, yes, it is a voluntary payment. But the law requires the department to issue a form DRC04, acknowledging that payment, by virtue of which they can say that, yes, he has already made the payment and we are not going to issue you any show cause notice. Otherwise, क्या करते हैं वो, the sword is always hanging on your head. You have made the payment, they don't have to recover any amount from you, but your sword is still hanging. They can always issue the show cause notice to you at any given point of time. They keep it open. So the law prescribes that you have to acknowledge that in DRC04, but I have not seen DRC04 barring a couple of cases where the DRC, after the DRC03, the DRC04 has been issued. And in one of those cases, that has been issued after we have approached the High Court. So department is not following the procedure. DRC03s are being generated as a matter of routine. And I would say that DRC03, where the payment has been made and assessee wants to fight that this amount should be refunded back to me. Or in certain cases, they just simply want to say that, all right, even if they don't refund this money back to me, at least there should be an adjudication of the matter. I want to file an appeal. In case I succeed before the higher forum, the amount should come back to me. Those litigations are also going on before the high courts, and that's a very positive side that the high courts are accepting the version of the assessee in all those cases. Mr. Devinder Singh has again mentioned about Bhumi Associates case. That was Gujarat High Court, where certain suggestions were made to the central government to incorporate. A circular did come after that, after the Bhumi Associates, and it has been provided that no forceful recovery should be made. But I would say that the suggestions which were made in Bhumi Associates have not been fully incorporated. Rather, they have diluted in the way that in case the assessee wants to make a payment, he can make it. So again, it will remain a matter of evidence whether the assessee has actually made that payment voluntarily or not. Be that as it may, still we can fight it. No DRC04 is issued, and secondly, we can lead the evidence. But let me tell you, all these litigations are only within the purview of the High Court under Article 226. None of the departmental authorities is or can go into the issues whether there is a voluntary payment or not. And secondly, even if it is involuntary, whether the refund can be given or not. So we have to be really sure as to which forum we are adopting. Then friends, we have the litigation on the issue of ITC blockage under Rules 86A. This is also quite rampant. They would, sitting on the computer, they would simply block it. And you will not get any assessee. You will not get any chance to, I'll just open the chat box. I think somebody has. Rishabh ji, I'll come back to you while taking up the questions, right? So I was on the ITC blockage under Rule 86A. They are saying that the ITC claimed by you is bogus in nature, so we are blocking it. No show cause notice, no prior notice, simply on the computer they would do it. Again, you don't have any option but to approach the High Court. Very recently, the High Court in the case of Rajnandani Metal has taken up a matter very interestingly, that you are saying that the ITC of the person, you bought it from say X, and ITC has been blocked, and X was issued a notice that you are fraudulently issuing was issued a notice for the cancellation of RC, that you are issuing fraudulent invoices, but later on his RC had been restored. His RC had not been cancelled. So where is the basis for blocking this ITC? So Rule 86 is also one of the areas where the litigation under Article 226 is going on before the High Court. We, of course, these cases have to be taken up on facts of each case. इसमें एक aspect और है sir. In some of the cases, there is a negative balance. A negative balance in the sense the ITC is not there, but they are blocking it to make it negative. That is not available to them because 86 clearly says you can block the ITC which is available with you in the credit ledger. So in case the ITC itself is not available, then the question of blocking that or making it negative would not arise. So आप उसका एक aspect देखिए, flip issue of that. Your ITC has been blocked, which is now it is being reflected in negative, say 5, maybe 20 lakh, 30 lakh, 40 lakh, 5 crores, whatever the amount, this is being shown negative. Now, if you file GST or 3B and you want to claim your current ITC, that will be adjusted against that amount and you will end up paying the amount of tax in cash. So meaning thereby, without even issuing show cause notice, without giving any opportunity to you, without passing any assessment order, they've already recovered the amount. So these are all the means of the department by virtue of which they are taking extreme coercive steps which are contrary to law. And everybody is being projected in a very, very bad, I would say, in a very bad picture of everybody is projected before the different courts and before the media and before the public. They're all fraudulent transactions which are taking place. But nobody is talking about the fact that we have not granted any opportunity to person to rebut those findings. We have been litigating on these issues, and in number of cases, it has been found that there were extraneous reasons for the department to proceed in the manner in which they have done. Friends, next is the issues relating to bank attachment, which are going on before the High Court. Section 83. This is also one of those first litigation issues which had arisen before the High Courts after Tran 1. A department would issue a summon, they would make a search or some sort of information comes to them. They would simply block the bank account of that person, crippling his business. He is not able to run the business. He is not able to pay to electricity. He is not even able to pay his electricity bills. He's not even able to pay his wages. He's not even able to pay the license fee like in the royalty, etc. So in a way, it's a complete shutdown of everything. And the interesting part is that the department doesn't get anything out of this. In case the bank account of a person is attached, they are not getting any penny out of it. They are not getting any money out of this. But the assessor's business has been closed down. They are rather, if he has to pay the GST, even that GST will not be paid even for the past period. So this is section 83 is something I could not understand how the department has even thought of framing such a section, except that it is causing harassment, which in return would get some kind of extraneous things for the departmental officers. I do not understand how I would say the lawmakers or the government can justify the imposition of section 83 in any case, because it doesn't generate any revenue at all. Rather, it blocks the revenue. Icing on the cake is 2 years back, it has been now made even more drastic. It has been even more draconian. Now that issue of the pending proceeding should be there and all those have been taken away. So these are all being done at the whims and fancies of the bureaucracy. They don't want people to function. They don't want people to earn revenue. They just want to block their business so that they would come to their office and maybe shake hands. We all know the reasons. So Section 83 is one of the most litigative grounds. CC account bande ka band kar diya. CC account cannot be blocked because this is not a property which is being held by him. But friends, here I want to say one thing under Section 83. Whenever Section 83 attachment takes place, I've seen professionals falter a little bit over there. They don't ask for the copy of the attachment order which has been passed by the department in DRC 22. And secondly, we are not filing the objections as required under Rule 159(5) before the commissioner or the officer who has blocked the bank, who has attached the bank. So all those things have to be done because Rule 159(5) says you have to file the objection within 7 days. Though they would never decide it for 7 months, but you are obligated to file that within 7 days. So we should take up all those pleas and we should file the objections before the authorities as soon as possible, as soon as the bank is attached, taking up all the pleas which are available to us. In case they don't do it, again, you have to go to the High Court. Then friends, we have a very, very serious issue under the GST pertaining to arrest. We had seen the unfortunate arrest of many chartered accountants. Atulji, can you please mute yourself?
Sorry, sir. Sorry.
Thank you. Friends, we had seen very unfortunate events which had taken place in the past, very recent past. Some of the chartered accountants had been arrested. And Gurgaon, the Faridabad case had been actually one of the eye-openers for all of us, that how far the department can go while victimizing the professionals and at the same time trying to save their own misdeeds, trying to save their own people. That was a case where a chartered accountant had simply certified that under Section 54 there is no undue enrichment, and that is the end of the matter. He has the certificate. Thereafter, within 2 or 3 hours, maybe 4 hours, the departmental officer acted upon that certificate. Not only acted upon that certificate, they verified everything else. And they eventually granted refund of crores of rupees. But when the question of arrest comes, they have arrested the chartered accountants because they were made the scapegoat. And the officer has been simply transferred. Unfortunately, the persons had to remain behind bars for, I think, about 4 or 5 months. The chartered accountant, without there being any fault. I would say I have personally seen that case. There was absolutely no fault of the chartered accountants in that, but still they have been victimized. Arrests have been taking place, not only the chartered accountant professionals, the arrest of other SSCs have also been taken place. So if we can, it is very easy to say that people are indulging in wrong activities and therefore the arrests are taking place. But we must understand that arrests are taking place to victimize or to blackmail others also as well. Though arrest in the face of it might look correct, but it may not be correct in all the cases. So when we look at all those media news that a person has been arrested for so much of GST evasion and all, those may not be correct in law. So I'll take up an example. I did a matter relating to the cyclic trading, which we normally call that, where a person creates his own firms where this ITC is rotated, but there is no actual evasion of tax in that case. The person had paid the tax. Thereafter, it was shown to X, Y, Z, which were his own firm. It came back to him as A, but there was no evasion of tax. Still, the person was arrested and he was put behind bars. He had to obtain a bail from the High Court. So looking at from media, or looking at from the departmental angle and putting it in the media is more of creating or sensationalizing the news rather than putting up the correct facts before the public. So we have to understand that arrest in all the cases may not be correct and we have to deal with those cases. In so far as relief is concerned, arrest, the relief on once a person is arrested, you have the only relief of obtaining a regular bail from the competent court. And in case you don't succeed, you can go before the district judge. In case you don't succeed, you have to go to the High Court. And that is the only way you can get a person out of the custody of the police or before in the judicial custody. Then, friends, the next litigation area is the constitutional vires of the Act. We have been litigating on various aspects of the constitutional validity of various provisions of the GST Act. Those are all very, very elaborate. We are talking about the section 13.8, the vires of intermediary definition have been taken up. The vires of section 16.4 under challenge. Vires of section 54, certain provisions are under challenge. So there are many, many issues which are being going on. So I'm not taking up because that will consume a lot of time. Then we have certain circulars which are bad in the eyes of law. I'll take up one example with you. Friends, there are certain classification matters which normally arise in GST. हम कहते हैं कि उसके ऊपर rate of tax should be 5%. The other people say the rate of tax should be, the department would say it should be 12% or 18%, depending upon what their interpretation is. Now I want to contest it. I want to say that I am right. I have my own arguments to make. Last year in October 21, a GST council meeting took place. In September 21, the meeting took place. And circular in 6th of October 21, the circular was issued saying that the item DDGS, which is dried distillers grain soluble, would be taxable at the rate of 5%, which the industry was claiming to be exempt. They came out with the circular, they gave some sort of lame reasoning in that, and that was made binding under section 168. Now, if looking at it from my angle, looking at it from the angle of from industry, you have issued me the show cause notice. I am before the adjudicating authority or I am before the appellate authority. You bombard me with a circular which is unilateral without any adjudication of the issues, without dealing with the aspects which I am raising before the authorities. And you say, no, this item is taxable at so and so rate. How can you do that? See, I ask a question from myself. How can you do that? Where is the consultation process? Where is the adjudication of that issue? Under the Act, it is only the adjudicating authority or the appellate forum or the High Court who can take up the issues, take up the adjudicative points, and thereafter they can decide on those issues. How can the GST council pitch in and say that no, this item has to be taxed in this fashion? In case you are so sure, you please do that by way of amendment in the entries. You please go ahead and do it prospectively. You can't be interfering in the matters which are already pending before the different forums. So the circulars to that extent have been challenged before the High Court. Those circulars are bad. And I've given you only one instance. There are many such circulars which are bad in the eyes of law. Circular relating to detention and seizure have also been challenged before the High Court that it is incorrect. So they would come out with some kind of lame, I would say some kind of very innocuous interpretation of law by way of a circular, as we have seen in the AAR and so on. They will come out with a similar interpretation of their own through circulars. So those circulars are also pending before challenge before the different high courts. Then, friends, one very interesting litigation which is pending before the High Court, which is pertaining to all our chartered accountants. In Form GSTR 9 and 9C, in case we have to discharge the liability, in case you find on the audit that some more liability is required to be discharged by the SSC. So how do we do that? How we discharge that liability? The note given in the GSTR 9C say that in case there is any excess liability which is required to be discharged by the SSC after the audit, then that has to be paid through cash ledger only. I fail to comprehend from where do they get such kind of ideas? From where do they get such kind of ideas? The tax, as per section 49, can be paid by me by use of credit ledger. How can, by virtue of a note in a form, you would say, no, 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 you have to pay this by cash. अरे भाई आपकी मर्जी थोड़ी है, ये तो लॉ बताएगा ना, ये तो एक्ट बताएगा. The act says I can discharge that tax liability through credit. How can you force me by virtue of by way of a forum, and you will put it on the GST and network and say, no, you have to pay this by cash? This actually sometimes you find it quite ridiculous. So those issues are also pending before the High Court, and we are quite hopeful that we should be succeeding in that. Atulji has asked a question that the authorities, despite the circular being illegal, are charging the tax and penalizing the taxpayer. What is the way out? Atulji, one thing we have to, I would say we have to change our mindset. Sometimes we get little too obsessed with what the departmental authorities are saying. We consider the authorities as to be the final word on everything. I think we, having qualified as a chartered accountancy examination, as I have already mentioned in the beginning, this is one of the most difficult exams in the country, the most difficult exam in the country, and we have read the nuances of the law of the different subjects threadbare. We have understood the GST law. We are discussing, we are deliberating on these issues on a regular basis. This organization, Voice of Chartered Accountant, had been doing it on a regular basis. We have been deliberating. Unfortunately, the departmental authorities don't discuss all these issues. They simply discuss all those issues as to how we can harass the assessee. So we as professionals should actually be taking up these matters before the authorities and should not buckle down. We should be locking horns with them, tell them this is the correct law, give them proper replies, and in case they don't agree, let's go and litigate before the higher forums, be it the appellate authority, be it the tribunal, be it the High Court. So there is a way out. There is a way out. We have to stand up and deal with this officer with a firm hand. Firm hand in the sense we have to have the backing of law, the understanding which we have. So we have to change our mindset that departmental authorities are not the final word on that. Let them do whatever they want. We will go in appeal. What's the difficulty in that? Moving further, friends. Well, we have talked about the different litigations which are pending before the courts. But the question arises how this litigation starts, how the litigation is generated. Under the GST Act, we tax professionals with chartered accountants, we normally encounter some show cause. So we encounter some person coming to us with, "Ke sir, ye summon aaya section 70 mein." So department ne bula liya hame. Kyun bula liya bhai? We do not know. They simply asked us to come and tender a statement. So I would say rather anybody who receives a summon under section 70 is normally coming to you trembling. He thinks as if he would be presuming, I don't know, I've committed some kind of offense, that they have summoned me, because summon is such a word that under section 70 they have summoned you. The inquiry starts. We have to deal with those summons. And normal thing is that in case you are able to comply with the summons, we should do that. We should be replying to those summons. But of course, there can be certain situations where the assessee is not in a position to go and tender the statement because he fears certain coercive steps which are likely to be taken by DGGI or the anti-evasion or any other authorities. So in that case, we have to deal it with a very, very, I would say very, very, we have to be very, very clear as to how do we deal with that situation. A client comes to you, he says that they are doubting my ITC, it may be incorrect, it may be correct. So in that situation, he might be apprehended, he might be apprehending arrest. So in that situation, you have to take all those steps which are possible to seek his personal liberty, and to maybe you have to file anticipatory bail, but that is not a very advisable way, because anticipatory bail are not normally granted in such like cases. But yes, you have to comply with the notice. Whatever you can do, you have to send the replies to those summons. And yes, you can always request for the personal appearance of a tax professional. There are many judgments where the presence of the professional has been allowed, but there are certain cases where the professional's presence has not been allowed. Having said so, summons is a situation which is a little tricky and it has to be handled on a case-to-case basis. So friends, the moment the SCN is, the inquiry is completed, we normally encounter a SCN, a pre-consultation notice in the form of DRC01 capital A. And then maybe in case the DRC01A is not settled, then we normally encounter DRC01, issue cause notice under section 73-74. Can we have a little discussion over here? How do we receive the notices normally? How do we receive the notices? The show cause notice which is issued to me under 74. 73 is very rare, but 74, 73 notices are issued. How do we receive those notices?
Through mail or in some time physically also without UDIN.
Yeah. So sometimes we receive it on the portal as well.
Yes.
So it is uploaded on the portal. Many friends have stated that it is available on the portal. So now taking this discussion further, whether a notice which has been put up on the portal, whether that is a valid service under section 169 or not. Can you say yes or no? In case the notice has been put up on the portal, whether it's DRC01 or any notice for that matter, say cancellation notice, this ASMT 10 or any notice, when it is put up on the portal, whether it is a valid notice or not, in case it is put up on the common portal or on the GSTN portal. Many friends are saying yes, it's a valid notice. So friends, let's examine this. I wanted to discuss this with you because I knew this is going to be the reply. Section 169. Akriti, can you share section 169 for a while? Akriti, are you there? All right. So friends, let's have a look at section 169 for a while. So 169 prescribes different modes of service. And if we have a look at section 169, D, 169D, it says by making it available on the common portal. So this is a mode which has been provided there that it can be put up on a common portal and it will be treated as to be a notice served upon the SSC. Now let's go to the definition of common portal. This is as per 226 says that the common portal would be the portal which is prescribed under section 146. Can we see 146, Akriti, for a minute? Can we go to 146? Do we have that? Anyways. Yes. Akriti, do we have 146?
Yes, yes, sir, 1 second.
संदीप जी मैं तुम कॉल बैक कर दा मेरा वेबिनार चल रहा है कोई Yes. Section 146. I think these are the rules. यस, इसको थोड़ा बड़ा कर देंगे प्लीज. हाँ, थैंक यू. So friends, if we read section 146, it says the common portal, the government may, on the recommendations of the council, notify the common goods and service tax electronic portal for, now kindly read it carefully, for facilitating a registration. That's one of the purpose for the recommendation of, for notification of the portal. For payment of tax, that's a second. For furnishing of returns, that's next. Then for computation and settlement of the integrated tax. Then electronic way bill, and for carrying out such other functions and for such purposes as may be prescribed. So this is the remaining thing. Now, if we have a look at the notifications issued in this regard on 29th of January 2018, whereby the common portal had been notified under section 146 by the government. Akriti, do we have that notification, please? Chalo, I'll proceed as it is. So if we have 146 notification, that says, yeah, this is there, the summary has been given. The notification has been issued on 19th of June 2017, number 4 of 17, for facilitating registration, for payment of tax, furnishing of returns, and computation and settlement of integrated tax. The portal defined is gst.gov.in. So friends, they have prescribed the notification, they have prescribed the common portal under section 146, gst.gov.in, for the purpose of facilitating registration, payment of tax, furnishing of returns and computation and settlement of integrated tax, but not for any other purposes which is defined under section 146. There is no other purpose they have stated in the notification. So this particular portal is available or notified for 4 purposes only. Now, there is something mentioned in the in section 146. The common portal, they can prescribe for electronic way bill, for which they have prescribed the electronic way bill would be e-way bill gst.gov.in. So it is different from the gst.gov.in. It is the e-way bill gst.gov.in. It's a different common. So common portal is not one. There can be multiple common portals. And for the purpose of invoicing, e-invoicing under Rule 48A, they have prescribed e-invoice 1.gst.gov.in, e-invoice 2.gst.gov.in, so on and so forth. So they have not prescribed the notified the common portal under section 146 for the purpose of service of notice as required under section 169. So till that time they do it, the service on the common portal is not a legal service. So we can take up this point for the purpose of litigating on the issues of service of notice in certain cases. So we should be aware of that. This is what I wanted to share with all of you, that this is a one litigative point and we are already on that issue. We are litigating before the court. Akriti, you can close this now. Thank you. Okay. So going further, friends, the moment the show cause notice is issued to us, we ought to file a reply to that. And while replying, we need to be aware of certain things. We need to check the show cause notice on certain aspects. We need to read, reread, again read the show cause notice, because show cause notice is quite elaborate whenever it is issued by the central authorities at least. You would find a lot of loopholes. You will find a lot of lacunas in their show cause notice. And one of the interesting aspects is कि उन्होंने inquiry करी. And in the inquiry, they have found certain statements which are against me. They have found certain people who are deposed against me. Very well, ऐसा होता है, it does happen. But there can be certain people who have deposed in my favor as well. they have gone to certain people who have given the statements or they have given the documents which favor me. But do you ever encounter such kind of show cause notice where they say that we had made the inquiries and such person has deposed against you and such person has deposed in your favor? At least I have not come across any such show cause notice where they say that such and such person has said that yes, I have made the transactions with you, or we have encountered such a person who has given the evidence in your favor. They simply keep shut on it. They will simply be mute on that. They don't even mention that in the notice. So friends, we normally call these statements which are in your favor to be the inculpatory statements, and the statements which don't favor you, exculpatory statements. And it is obligatory upon them, taking clue from the criminal law, that the notice ought to have not only the exculpatory statement, but they need to have inculpatory statements as well. It is for the adjudicating authority, or it is for the higher authority to see which evidence would weigh in the favor or against the SSC, or for that matter, anybody who is affected. जब पुलिस चालान पेश करती है, चार्जशीट फाइल करती है, they can't say that we are going to file the evidence which is against the accused. They need to file complete evidence, whether it is in favor or against him. And thereafter, it is for the court to look at that evidence and come to a proper conclusion. I'll give you an example. A person has been charged with murder. Say he's a lookalike of some person, or he's a twin. A person has been charged with murder. But there is a mistaken identity. The other person has been now booked by the police. He leads the statements. He says that I am innocent. I am not guilty. The police gather these statements. Police gather the investigation, and 50 people over there who had watched the murder or some kind of criminal activity on his part, they would certainly say that yes, we had seen this person committing the murder. We have seen that this person has done so and so wrong. But suppose the person says, no, on that day I was actually at a railway station catching a train at that point of time when the murder took place. Now the police goes and finds from the CCTV footage of railway station that yes, this person was there, and they take that into possession, but they don't make it a part of the charge sheet. Now the person would not even know that the CCTV footage is there. They have gone there, the statement is there, and I am found over there in the CCTV footage. So there is no question of me being present at the place of murder. Now this particular aspect, in case it is not incorporated in the challan, would cause a huge or grave injustice. And therefore, it becomes imperative for the department to include not only the state things which are against the SSC, but also those things which are in favor of the SSC. And let there be an adjudication on that aspect. It could be this way or that way, whatever it is. So that is one aspect which we need to look at the time of encountering a show cause notice. So show cause notice issue हुआ, हमने different चीजें उसमें देखी हैं. एक शो काज नोटिस में दिन हम देखते हैं, ये देखते हैं कि शो काज नोटिस में उसने प्रिस्क्राइब टाइम पीरियड के अंदर है कि नहीं है, प्रॉपर ऑफिसर ने इशू करा है कि नहीं करना. दीज आर द बेसिक थिंग्स व्हिच यू नॉर्मली लुक एट इट. एक चीज और जो शो काज नोटिस में हम लोगों को देखनी है वो ये है कि क्या 74, 73 की रिक्वायरमेंट्स को फुलफिल कर रहा है कि नहीं कर रहा, वेदर इट फुलफिल्स द रिक्वायरमेंट ऑफ दैट सेक्शन और नॉट. आई एनकाउंटर्ड अ केस where the allegation against the SSC was that you have issued the bills the invoices have been issued to certain registered dealers, whereas the actual goods have been sold to the petty dealers, and therefore we are making an allegation against you that we want to impose tax upon you for wrong issuance of invoices, that you have issued the invoices which are not permitted under the law, therefore we want to impose tax upon you under section 74. Now I fail to understand under section 74 how it is possible. Because 74 envisages only 4 situations. 1, where the tax has not been paid, where the tax has been short paid, where the refund has been erroneously granted, and fourth is the case where the ITC has been wrongly taken. Now, in that scenario, if we apply all those four situations to the facts of the case which I have discussed with you, Section 74 doesn't apply. It is not a case where I have not paid the tax, rather I have paid the full tax. It is not a case where I have paid the short tax. It is not a case where I have taken any refund, because I have not taken at all. Fourth, it is not a case where the ITC is wrong. My ITC is absolutely fine. I have purchased the goods from a multinational company. So how do my case fall under Section 74? The correct section in that scenario could be Section 122, where the penalty could be imposed. But looking at from that pre-deposit angle, the department wanted to impose huge liability upon me by way of imposition of tax and say, no, you are a culprit, you are a bad man, therefore we want to proceed under Section 74. So we have to look at all those aspects while encountering a show cause notice. So दोस्तों, show cause notice issue हो गया, हमने उसका reply file कर दिया है. Now the adjudication will take place. Adjudication, I very rarely see that the adjudication goes in favor of the SSC, or some peanuts are given at the end of the day to the SSC that yes, this we are accepting your version, but more or less the show cause notices are confirmed, and we all know the reasons for that. So I need not elaborate upon that. The adjudication takes place, then we have to file the appeal within 90 days, plus 30 days, of course, is the period during which the delay can be condoned. That appeal has to be either before the Joint Commissioner or the Additional Commissioner or the Commissioner, as the case may be. Or in certain cases where the state tax officer has done it, then an appeal has to be filed before the appropriate authority as prescribed under the different rules of the state GST acts. So that is where the appeal takes place, where you have to make a pre-deposit of 10% of the tax. And if you had a reason whether this pre-deposit can be made from the credit ledger or not, Odisha High Court had taken a view where they say that pre-deposit cannot be made by way of credit. But later on, Maharashtra, the Bombay High Court and some other courts have also taken a view that yes, the pre-deposit can be made through the credit ledger also, especially when the form itself prescribes so, and the act also, Section 49, allows me to make the pre-deposit through that. The moment you make the pre-deposit of 10%, the remaining amount gets stayed automatically, that we all know, so I need not elaborate upon that. थोड़ा सा मैं डिस्कस करना चाहूंगा कि हम लोग शो कॉज नोटिस जब आता है तो उसको कुछ चीजें हैं जो एस्पेक्ट्स हैं which is like a checklist for us. We should be taking care of those. One is that we are in the habit of taking multiple adjournments. That should be avoided. As and when it is possible to comply with the requirements of the notice, we should do that. We should file the necessary reply. In case we are wanting to seek more time, because sometimes the show cause notices are very elaborate and we need to have more time to gather the information and all, then we should make a proper application for seeking extension of time. We should not be leaving our fate to the mercy of the departmental authorities, who can pass any order in case there is no reply given to them within 30 days. Then we should make every endeavor to substantially comply with the requirements of the notice. In case they are asking us to submit certain documents, we should do that. We should actually make it a point that कई बार क्या होता है, वो रिटर्न्स मांगते हैं आपसे 3B की रिटर्न्स, या आपसे इनकम टैक्स रिटर्न मांगते हैं, टैक्स ऑडिट की रिटर्न मांगते हैं, टैक्स ऑडिट रिपोर्ट मांगते हैं, या कुछ भी इस तरीके का मांगते हैं, which is actually you can't hide anything, that is all available with them otherwise also. बैंक स्टेटमेंट्स मांगते हैं. Those things should be shared immediately, because otherwise they would say we had asked for the information, they have not provided. That is good enough for them to confirm this show cause notice itself. Barring the disputable issues or disputed documents, we should always make an endeavor to submit whatever documents we can easily before the authorities is concerned. So that should be our endeavor. एक aspect जो सबसे important है, जो हम लोग मिस करते हैं, whenever there is a case of ITC availment, they say that the ITC is disputed. In that scenario, it is always based upon the statements of the other authorities. It is based upon the reports sent by the other departmental forums, like from different states. उन लोगों ने वहां जाके कोई पंचनामा करा होता है, सर्च करी होती है, बेस्ड अपॉन दैट दे से द पर्सन इज नॉट एग्जिस्टिंग, देयरफॉर वी वांट टू डिनाई यू द आईटीसी. Now we have to make it point that we seek cross examination of all those persons while filing a reply to the show cause notice. We have to seek cross examination because that is one of the most fundamental principles of natural justice, that in case a person is being asked to be present for the cross examination and the department refuses to bring him into the witness box, in that scenario the order cannot be sustained, and you can note down the judgment on that. Andaman Timber versus Union of India, where denial of cross examination itself led to the deletion of the entire demand by the Supreme Court. So that is something which is so rooted in the adjudicatory proceedings insofar as the legal procedure is concerned, because आपके पास क्रॉस एग्जामिनेशन के बगैर और कोई साधन भी नहीं है जिसके थ्रू के हम लोग इस चीज को साबित कर सकेंगे हमारी जो परचेजेस हैं वो करेक्ट हैं या नहीं है, बिकॉज दैट वुड आल्सो लीड टू द कंक्लूजन as to whether you should be granted the ITC or not in view of the various Supreme Court and various High Court judgments on that aspect. Then
जजमेंट का नाम बता दें सर एक बार दोबारा.
Sir, Andaman Timber Store versus Union of India. Akriti, can you share the citation with him? Andaman Timber. I'll just send it to you on the chat. ठीक है जी. Andaman Timber Store versus Union of India. You can note down the name. ये हो रहा है. देन एक चीज और आपको शोकॉज नोटिस हैंडल करते हुए जो देखनी है वो है कि आपको पर्सनल हियरिंग जरूर मांगनी है. कई बार क्या होता है हम मिस कर जाते हैं, हालांकि सेक्शन 76 में ये प्रोवाइडेड है 75 में कि अगर आपके खिलाफ कोई भी ऑर्डर पास होता है तो पर्सनल हियरिंग ग्रांट करनी जरूरी है, बट देन इट बिकम्स अगेन इशू ऑफ लिटिगेशन. तो आपको पर्सनल हियरिंग मांगनी ही है हर केस में, क्योंकि पर्सनल हियरिंग के बगैर आप अपने इशू को सेटल नहीं करा सकते इन नॉर्मल वे. देन एक चीज और है कि जो डॉक्यूमेंट्स पे हम लोग रिलाई अपॉन कर रहे हैं वो डॉक्यूमेंट्स हमें सारे के सारे अटैच करने हैं साथ में, इधर इन दी सॉफ्ट फॉर्म और इन दी हार्ड कॉपी फॉर्म. अगर वो आपके वो रिलाई अपॉन कर रहे हैं 1000 पेजों के ऊपर, 500 पेज के ऊपर, देन वी शुड ऑलवेज मेक एन एफर्ट कि हम वो सारे के सारे चीजों को काउंटर करें. अगर हमारे पास सबूत है कि हमारी परचेजेस सही हैं या हमारे डॉक्यूमेंट सही हैं तो हमें वो सारे के सारे साथ में लगा के वी हैव टू अपेंड विद द रिप्लाई एंड सबमिट विद द डिपार्टमेंट. Sometime जैसे अभी I think one of our colleagues had mentioned that the departmental authorities don't accept, they don't agree. We don't want them to agree. Let them not agree with us, but at least we have to do our job. We have to submit the documents. Let them pass a wrong order. Only then you will succeed. Otherwise, in case we don't submit the documents, he has every reason to say that they have not submitted any evidence. And in case we have not submitted the evidence, then show cause notice is bound to be confirmed. And you can't take up those evidence before the higher forum. That is a specific provision under section 107. Unless you show that there was a sufficient cause for not producing in the first place. अब वो तो आप कर नहीं ना सकते अगर आपके डॉक्यूमेंट्स पहले दिन में थे. तो आपकी ड्यूटी बनती है कि आपको ये सारे के सारे डॉक्यूमेंट्स इन द फर्स्ट प्लेस यू हैव टू सबमिट बिफोर द अथॉरिटीज. So, should we proceed on the real estate or we get the questions on this, sir? First,
सर दो Q&A में 2 क्वेश्चन है दीपांशु गोयल जी के.
जी बोलिए.
If SCN having reason for SCN is typed other only, what to do with that? ये कहना चाह रहे हैं कि SCN other category में typed है. जाओ.
Sir, I think they would always be giving you the reasons, the detailed reasons for that कि आपने उन्होंने शो कॉज नोटिस इशू क्यों करा आपको. Can we have him on the chat?
Yes, I'll try, sir. एक सर उन्होंने लिखा शो कॉज नोटिस फॉर कैंसिलेशन ऑफ रजिस्ट्रेशन.
Show cause notice for
cancellation of registration.
Yeah, I didn't get the question. What is the question?
दीपांशु जी आपको सर अलाउ किया सर, पूछिए क्वेश्चन.
सर बेसिकली मैं पूछना चाहता हूँ अगर शो कॉज नोटिस में सिर्फ एक ऑप्शन डाल दिया कि अदर, कोई रीजन नहीं है, कुछ नहीं है, रजिस्ट्रेशन कैंसिल कर दिया, तो सर क्या करना चाहिए उसके लिए? कोई रीजन नहीं है, कोई डॉक्यूमेंट नहीं मांगा।
हाँ ठीक है, सो यू आर टॉकिंग अबाउट द शो कॉज नोटिस इशूड फॉर द पर्पस ऑफ कैंसिलेशन ऑफ रजिस्ट्रेशन, वहां पर सिर्फ अदर्स लिखा हुआ है ना, उन्होंने स्पेसिफिक जो रीजन देने होते हैं वहां पर अदर्स लिख दिया, दैट इज दिस इज व्हाट यू वांट टू से, राइट?
यस सर।
Dipanshu ji, that's a very simple thing. You have to revert back to them saying that what do you mean by others? You kindly specify me the reasons so that I can file a proper reply to that.
Okay sir.
That's a very simple thing. You have to, this is what I'm saying. We should not be presuming anything. Let us not presume that I have committed such and such fault. They have stated in the notice that others, you go back to them and file reply that why you are saying that this RC is to be cancelled on the ground of others. You specify me the exact reasons for that.
सर अगर अपील का टाइम भी निकल जाता है, मतलब 1 साल हो जाए शोकॉज नोटिस को, कैंसिल हो जाए, तो कुछ होता है सर रेमेडी या कुछ?
उसके लिए ऑलरेडी हाई कोर्ट में लिटिगेशन पेंडिंग है. मद्रास हाई कोर्ट हैज गिवन अ जजमेंट इन फेवर ऑफ एसएससी, but for Punjab Haryana High Court we have got a notice issued in this case that RC should not be cancelled at all. In case it's to be cancelled, there it should be restored the moment the person complies with the requirements of the law. जैसे कई लोगों ने 6 महीने नोट वो नहीं फाइल करी, रिटर्न्स नहीं फाइल करी, उनकी कैंसिलेशन हो गई. So since they already filed the returns, so we want them, the RC should be restored. High Court has issued notice on that, considering under 226 it should be done. उसको आप उसको एक different angle से सोचिए. As per registration provision section 23, I think compulsory registration का जो provision है, उसमें मुताबिक you have to obtain the registration in case you are doing some transaction, GST transactions. On the other hand, you are not granting him the registration. So how do you reconcile these two provisions? अगर किसी बंदे ने किराए पे जगह दी हुई है, let us, I'll give you an example. A person has given a property on rent, commercial property है जिसके ऊपर GST लगना है और GST पे भी हो रहा है, all of it, but he doesn't file the return for say 6 months for whatever reason, ABCD reason, उसको किराया नहीं आया, he has not filed the return, his registration is cancelled, and thereafter he does not file the appeal. Property is already on rent, the GST transaction is being conducted, supply is there, the taxes to be paid. You are saying we will not grant him the registration, we have cancelled the registration to him. How do you reconcile these two provisions? Ultimately, he has to file the return and he has to pay the tax. So on the one hand, you are saying, yeah, you have to obtain the registration, you can't work without registration. On the other hand, you are saying, no, you have, your registration is cancelled and will not grant you that. Yes, this is the case of Suguna Cut Piece Center versus Appellate Authority. My colleague has already mentioned that in the chat box. You can note it down.
Sir, next अतुल पुरी जी का क्वेश्चन है. अतुल सर.
अतुल जी बोलिए.
संदीप जी, मेरे एक मैटर में उन्होंने ITC डिनाई कर दिया है on the ground that the party has not filed income tax return.
सर कोई खास नहीं होगा.
मेरे को समझ नहीं आ रही उसका मैं क्या करूं.
अतुल जी, I think that's a very easy thing for you. अगर ऐसे कारण पे कर रहा है तो बहुत अच्छा है, आप सिंपली लिख के उसको अपील कर सकते हैं. अगर ऑर्डर हो गया, एडजुडिकेशन ऑर्डर हो गया, you can file an appeal saying that this is not a ground for the denial of my ITC.
नहीं, अभी तो उन्होंने शो कॉज भेजा है, तो should not be denied. तो मैंने उनको बोला कि भैया एक आदमी की इनकम टैक्स रिटर्न भरने से हमारा उसका हमारे कैश उसमें ITC मेरे को अपीयर हो रहा है, मेरे को उससे क्या लेना देना, उसके पर्सनल कंडक्ट को थोड़ी मेरी जिम्मेदारी है.
अब मैं वही तो कह रहा हूँ ना, वो तो आपको इस बात पे भी नोटिस दे सकते हैं ना कि उसने शादी नहीं करी हुई है, वो कुछ भी तो आपको नोटिस देने में तो कुछ नहीं जाता. आप एक बात सोचिए ना अतुल जी, उन्होंने आपको नोटिस दिया, इसी बहाने आपको बुला लिया, चाय पियेंगे साथ में, शक्कर भी तो डलवाएंगे आपसे चाय के अंदर.
नहीं, चाय तो मैं पी के आ गया उसके साथ, सुपरिटेंडेंट के साथ.
जी.
बट ये अजीबोगरीब नोटिस आ रही है इस तरह के ना.
सर वो करते हैं. आप और एक बात और देखिए, आई एम नॉट सरप्राइज इन केस दीस नोटिसेस आर कंफर्म्ड एज वेल.
नहीं, कंफर्म तो नहीं हुआ, मैंने उसको समझा दिया.
मैं कह रहा हूँ आई वुड नॉट बी सरप्राइज इन केस दिस इज कंफर्म्ड. सब कुछ हो रहा है यहाँ पर, सब कुछ हो रहा है.
नहीं, मैंने उसको ये भी समझाया, मैं कहा देखो इनकम टैक्स में अगर उसकी 2.5 लाख से नीचे की इनकम आ रही है तो रिटर्न क्यों भरेगा वो. और डिपार्टमेंट को करने दो ना उसको नोटिस कि तुम्हारा भैया इतना GST में तुम्हारे इतनी टर्नओवर आ रही है और तुम रिटर्न नहीं भरे, लेट द इनकम टैक्स डिपार्टमेंट टेक दैट एक्शन. इसमें हमारा क्या लेना देना भाई. मैं उसके घर जाके उसके कंधे पे बंदूक रख दूं कि ले भैया तू रिटर्न भर अपनी. एंड हाउ डू आई नो भर रहा है कि नहीं भर रहा.
Exactly.
And for that matter I cannot even question him.
Absolutely. And And that's not the ground for non-grant of the ITC.
बिल्कुल, absolutely.
नेक्स्ट
मैंने उसको-
आदित्य जी, अतुल सर
Thank you,
कुछ
sir.
और?
Thank you.
Thank you, Atul ji.
नमस्कार
आदित्य
संदीप जी।
करीवाल
Namaskar ji.
संदीप जी, there's this rampant thing going around in mostly all the jurisdictions of Punjab that
जी.
state tax officers are sending blanket letters to every and any GST number registered under them.
जी.
Whereas in many of cases, these numbers have been allotted to center registration, but they plainly say that we have jurisdiction, will issue notice under section 70, basically summons and then the scrutiny of returns and doing their thing. So the thing is, they say when they say they have jurisdiction, and we oppose to that as in this is a error in assumption of jurisdiction, because once they have been, the order has been passed by commissioner and division of taxpayers has been done. So their action is like on on the very initiation of action is without power. So how to go about it? Whether we should cooperate with all these proceedings, because at the on facts level, all the things are there with the assesses, but this blanket action is done like it's a rampant practice. So we have thought to represent it to Commissioner Punjab by writing a representation. What is your take on that subject matter? How can we deal with it?
Aditya, good to see you here. I think आपने बड़ा
We met last
आपने-
week, left little earlier on Wednesday.
आपने बहुत ही वैलिड और बड़ा इंटरेस्टिंग क्वेश्चन एक थ्रो करा है. You see, this question of cross empowerment, if I am not wrong, I think we are talking about the cross empowerment of the officer.
Perfect.
That's right.
Right.
The issue of cross empowerment has been now going on for quite some time. While there are two aspects of this, one is the concurrent use of the power by both the authorities, concurrent use of the power by SGST and CGST. That's a concurrent power. Second is the simultaneous use of power by both the authorities. I hope you understand the difference between these.
Definitely.
Right. So when we talk about the concurrent use of the power, which is your question, that the authorities, the assessee has been allocated to one particular jurisdiction, but the other authority, say they have been allocated, they have been given to the state authorities, but the central authorities are issuing the notice to him, summoning him and doing whatever action they can. In that scenario, the point which has been taken by you might have some value. You are representing before the commissioner, but I don't think the state commissioners have any authority. विपुल जी, एक बार आप जरा पॉज कर लेंगे प्लीज जी. तो हम उसमें जो आप कमिश्नर के पास कर रहे हैं सर, that commissioner may or may not agree, but commissioner doesn't have too much of I would say resources to actually give you any relief on that aspect. But talking about the law, the powers of the central GST officer to act under the state GST Act. Now, kindly try to find out the difference. State GST जो एक्ट है, जो पंजाब GST एक्ट है, उसके अंदर सेक्शन 6 लिखा हुआ है, जिसके अंदर उन्होंने सेंट्रल GST ऑफिसर्स को भी प्रॉपर ऑफिसर बना दिया है, सब्जेक्ट टू द कंडीशंस as the GST Council shall prescribe. Kindly note down these last 2-3 lines. As the GST Council shall prescribe in that regard. Now, argument which we are raising is that a central GST officer is not empowered to take any action whatsoever for the imposition or collection of tax under the state GST Act. I hope I'm clear.
Right.
Okay. So when he is not empowered to take any action except under section 6.2.
Yes, sir.
Yeah, sorry, not 6.2, 6.1. He cannot actually issue me any notice under the state GST Act. Why I'm saying so? Now I'll give you the reason for that. जब 2017 में GST काउंसिल की मीटिंग्स हुई थी, उस टाइम पर क्रॉस एम्पावरमेंट का इशू बहुत ज्यादा रेज हुआ था. अनफॉर्चुनेटली फॉर द लास्ट 4 years दैट इशू हैज नॉट बीन डिस्कस्ड. In those meetings, an agenda item was there that how do we divide the jurisdiction of the officers who are different dealers. And proposed notifications were also placed on record. The minutes were there that these persons will be the officers for the purpose of section so and so, so and so, so and so, and so and so. That CGST officer would be the proper officer for section so and so, so and so. Similar to the State GST Act. But that proposal did not get through. The states did not agree for that in the GST Council, and that agenda item was not approved. The only thing which was approved was grant of refund under section 54, and we all know in 2017 the state GST officers were given the powers to grant refund for CGST, and similar powers were given to the central GST officers to grant of refund under the SGST. Barring that, there is no other notification which has been issued till date for exercise of powers of SGST Act by the CGST Act and vice versa.
Sir, I have a little proposal to that thing. I beg to differ on two aspects. Sir, I would like to put forth before you. The first thing is that all the powers flow to the people from for these GST officers are from by virtue of section 5. 5(1) of the state GST Act says that anything subject to the limitations and conditions prescribed by commissioner. So to that effect, commissioner has passed an order wherein Punjab GST commissioner as well as CGST commissioner both have agreed upon an order whereby they have stated a list that certain taxpayers are assigned for the
वो तो आप डिवीजन की बात कर रहे हैं ना सर, वो आप डिवीजन की बात कर रहे हैं. मैं आपको I am going a step further. Suppose they have a plea that the assessee which has been allocated to me or allocated to state GST officer, for him also I can issue a notice. I say you can issue a notice to him under the CGST Act only. You cannot issue him a notice under the SGST Act. Try to appreciate that. I'm saying आपने कहा कि आपने 10 करोड़ रुपए का आपसे मैंने टैक्स लेना है, जिसमें 5 करोड़ CGST के हैं, 5 करोड़ SGST के हैं, तो आप वो नोटिस को you have to confine it to only 5 crores, not to 10. You cannot take it to 10 crores.
Perfect.
Right. So what I am trying to say that the central GST officers are not empowered to issue any notice under the SGST Act. Vice versa, SGST officers are not empowered to issue any notice for the CGST Act. Therefore, in case they want to charge tax from me, they want to issue me a notice, both the authorities have to simultaneously issue the notice and decide it. That would be the situation of law as of today. Because that cross-empowerment issue has actually not been implemented by law. Because they have not prescribed any such conditions. They have come out with the circulars which are bad in the eyes of law. They have come out with a circular in October 17 itself, where they say the CGST officers are empowered to take it further, and although they have mentioned about the agenda meetings also, they don't say that that agenda did not get through. So that issue is live. There is some judgments which have been mentioned by my colleague also in RC Industries and others also. There was a case of some mishprak in Punjab Haryana High Court, which was not in our favor. But that was the case where there was simultaneous use of the powers. That SGST officers have also issued the notice and CGST officers have also issued the notice. So that was slightly different, where we had gone to the court and said that both the authorities cannot proceed together. So in that there is absolutely no problem, because section 6(2) itself bars that simultaneous exercise of power is not possible. So that's a different aspect. But the point आपने raise करा देते, that's a very valid point. I think we should litigate on that. We should take up that issue before the commissioner.
And I would like to welcome Batra ji for the session. Thank you so much for joining, sir.
Welcome Batra ji.
Thank you Sandeep ji.
हाँ जी सर.
सर अगर आदित्य जी का क्वेश्चन हो गया तो नेक्स्ट सर देखिए देवेंद्र जी का क्वेश्चन है
जी प्लीज.
और उसके बाद विपुल जी का क्वेश्चन है. देवेंद्र जी प्लीज पूछिए. देवेंद्र जी प्लीज गो अहेड सर.
Good evening Sandeep sir.
Also sir please make it short also.
Sir, good evening. Am I audible?
Yes,
please,
very
go ahead,
much
sir.
audible, sir. Devinder,
ओके
please go ahead.
सर, मेरा क्वेश्चन है, एज्यूम कीजिए कोई केरला में स्टेट अथॉरिटीज के पास कोई प्रोसीडिंग चल रही है मिस्टर ए की, और ए ने कोई परचेज करी हुई है, सेल या परचेज करी हुई है मिस्टर बी से, जो दिल्ली के अंदर है।
ठीक है जी।
वो बी, दिल्ली वाले को चिट्ठी नहीं लिख रहे बी को, बट बी की जुरिस्डिक्शन को स्टेट वालों को चिट्ठी लिख देते हैं कि ए ने ये बी से खरीदा हुआ है, और दिल्ली स्टेट वालों को चिट्ठी भेज देते हैं बी का नाम देकर।
ओके,
क्या दिल्ली स्टेट वाले बी को सम्मन भेज सकते हैं 70 के अंदर? इंक्वायरी पेंडिंग तो केरला वाले के पास है मिस्टर ए की,
नहीं तो बी वाले
दिल्ली वालों के पास कोई पेंडिंग नहीं है। क्या दिल्ली वाले सम्मन भेज सकते हैं 70 का, बी को बुला सकते हैं?
देखिए ऐसे है, जो बी है वो दिल्ली में है ना।
यस 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 यस।
तो दिल्ली वाले बी को डेफिनेटली बुला सकते हैं सर। दे कैन ऑलवेज मेक एन इंक्वायरी, दे कैन।
बट सर जैसे सेक्शन 70 की समन की रिक्वायरमेंट है दैट देयर शुड बी इन एन इंक्वायरी, दिल्ली वालों के पास तो कोई इंक्वायरी पेंडिंग है नहीं, इंक्वायरी तो पेंडिंग है केरला वालों के पास।
सर उनके पास मैसेज आ गया ना केरला का, तो इंक्वायरी शुरू हो गई। व्हाट्स द डिफिकल्टी इन दैट? व्हेन वुड यू से दैट इंक्वायरी हैज स्टार्टेड? केरला ने भी तो ऐसी करी थी जब उन्होंने ए से इंक्वायरी करी थी। दैट टाइम आल्सो नथिंग वाज पेंडिंग। बी वाले दिल्ली वाले अपने डीलर से इंक्वायरी करना चाहते हैं। आई थिंक देयर इज नथिंग।
इनकी कोई ओपिनियन फॉर्म करना, मतलब जस्ट ऑन द बेसिस ऑफ लेटर रिसीव्ड, दैट्स एनफ।
Sir, that is not, they have not formed any opinion. See, they have got any information, and they are rather duty bound to inquire it from B. कि भैया ये आपकी ट्रांजैक्शंस के बारे में इंफॉर्मेशन मिली, आप इसके बारे में बताइए क्या कहना चाहते हैं। आई थिंक दैट्स
बट सर वैसे सेक्शन 70 के बारे में जितना मैंने पढ़ा था, दैट देयर शुड बी एन इंक्वायरी पेंडिंग रेदर देन टू क्रिएट एन इंक्वायरी। अगर वो बी को बुलाते हैं तो दे आर क्रिएटिंग एन इंक्वायरी रेदर देन
इंक्वायरी पेंडिंग होने से पहले इंक्वायरी क्रिएट तो कहीं ना कहीं होगी ना। पेंडिंग कैसी होगी? It cannot be near. How would an inquiry start?
ओके ठीक है, थैंक यू सर। सर वो एक वो जजमेंट प्लीज चैट बॉक्स में शेयर कर दीजिएगा, अंडमान वाली, जो अंडमान वाली क्रॉस एग्जामिनेशन की आपने बोला था।
2 बार की है देवेंद्र जी,
सर अंडमान की आ गई है सर चैट बॉक्स में।
ठीक है, थैंक यू।
नेक्स्ट सर विपुल जी प्लीज पूछिए सर।
जी नमस्कार गोयल साहब, नमस्कार बत्रा जी।
जी विपुल जी।
सर मेरी जो क्वेरी है दिस इज रिगार्डिंग इन्वर्टेड ड्यूटी रिफंड्स।
जी जी बोलिए।
in our city we have been receiving SCN on the when we file the refunds of inverted duty. They are making 2-3 queries. They are raising 2-3 concerns and they are refusing the refunds on those grounds. One is this: they say that when the purchase is more than sales, we will not allow you inverted duty refund. When purchase of the raw material is more than sale of finished products, it means it is not the case of inverted duty, it is the case of accumulation of duty. This is what I have got the order with me. They have passed.
अगर आपकी सर आप देवेंद्र जी सिंपल सा क्वेश्चन उसमें तो ये है कि अगर आपकी जो फाइनल प्रोडक्ट है उसका ड्यूटी रेट जो है वो कम है आपके रॉ मटेरियल के रेट से, then it will fall under inverted duty structure. How would
they are saying that whatever raw material you have purchased that is consumed within a span of 3 months, and I am filing the refund for 1 month, and they are saying that your purchase is much higher than the sales.
I think that will not make any difference. They are absolutely wrong on that.
Yeah, but they are doing it, sir, in our part of the country.
वो बात हम कर चुके हैं सर पहले कई बार आज ही डिस्कशन में।
अच्छा सॉरी सर, एक पॉइंट इसमें और कर रहे हैं सर।
उनको अपना काम करने दीजिए, हम अपना काम करेंगे।
वो तो चलो अपील में सर हम जाएंगे ही।
जी जी जी।
एक क्वेश्चन और है सर, जो फार्मूला 89.5 सबसेक्शन रूल 89.5 में दिया गया है।
जी जी।
इन्वर्टेड ड्यूटी टर्नओवर डिवाइडेड बाय एडजस्टेड ड्यूटी टर्नओवर इनटू नेट आईटीसी माइनस ड्यूटी ऑन जीएसटी ऑन इन्वर्टेड ड्यूटी। सर इसमें एक इशू आ रहा है, जब किसी पार्टी ने सेम जो प्रोडक्ट वो बना रहा है, जो प्रोडक्ट वो क्या करते, कई लोग ऐसे हैं जो मैन्युफैक्चरिंग भी करते हैं और ट्रेडिंग भी करते हैं। मैन्युफैक्चरिंग भी वही प्रोडक्ट की करते हैं HSN कोड की, और ट्रेडिंग भी वही प्रोडक्ट की करते हैं।
जी जी जी।
जब हम ये फार्मूला उनको लगाते हैं ना जी, तो उनका जो है रिफंड जो है वो प्रोपोर्शनेटली, अगर जितनी प्रोपोर्शन की ट्रेडिंग होती है उतने प्रोपोर्शन से काफी कम हो जाता है, मतलब 50% रह जाता है उसका रिफंड। आप समझ ही रहे हैं, क्योंकि उसमें वो इन्वर्टेड ड्यूटी में आना नहीं है। तो मेरा क्वेश्चन ये था कि कोई भी बंदा अगर सेम HSN कोड में ट्रेडिंग कर रहा है और 5% से माल खरीद रहा है और 5% से बेच रहा है, वो तो आपस में निल हो रहा है। तो हमें ये वाला फार्मूला क्या कहीं चैलेंज अभी तक हुआ है या कैसे, इसका क्या मेरे मतलब यहाँ पे बहुत बड़ा इम्पैक्ट आ रहा है, लोगों को ट्रेडिंग करने के लिए अलग फर्म्स बनानी पड़ रही है।
लेट मी आंसर विपुल जी ऐसे है कि आपको याद होगा एक लिटिगेशन इन्वर्टेड ड्यूटी स्ट्रक्चर के ऊपर हुई थी वीकेसी फुटस्टेप्स की, जिसमें गुजरात हाई कोर्ट हैड डिसाइडेड इन फेवर ऑफ द एसएससीज एंड मद्रास हाई कोर्ट हैड डिसाइडेड अगेंस्ट द एसएससीज। आई थिंक यू वुड रिकॉल दैट।
अच्छा जी।
So that matter had traveled to the Supreme Court, and Supreme Court had in a very elaborate judgment had decided in favor of the revenue, saying कि आपको जो input services है उसका refund नहीं मिल सकता. While doing that, there was a challenge to the provisions of Rule 89.5 as well. Unfortunately for us, Supreme Court did agree that 89.5 rule is not correct, but still upheld it. They agreed that there is something wrong in the formula of Rule 89.5, which we had projected before the court, but still they said that this can be removed by the GST Council, and they have now amended Rule 89.5 after the judgment of VKC Footsteps. But having said so, I'm conscious of the fact for the problem which you are saying, that still it does not meet the requirements of law, and therefore 89.5 in its amended form can still be taken to the court.
Sir, what is your advice in those type of cases?
Sir, जहाँ पर आप when you are encountering any provision which according to you is not as per provisions of law, then you have no other option but to challenge the vires of that before the High Court under 226. There is no other.
Till that we whether we should refrain from filing the refunds.
You can always file the refund, sir. You can file the refund, go to the High Court, and thereafter whatever would be the outcome of the High Court decision or the Supreme Court decision, depending upon that your fate will be decided. You have to litigate, otherwise आपके 2 साल निकल गए तो आप refund apply नहीं कर पाओगे.
अच्छा, ऐसी कोई पेंडिंग नहीं है सर?
सर 89.5 के ऊपर एज ऑफ टुडे नहीं है, 89.4 के ऊपर जरूर पड़ी है, कैपिटल गुड्स से रिलेटेड पड़ी हुई है, 89.5 की नहीं है, क्योंकि वीकेसी फुटस्टेप्स के बाद अभी अमेंडमेंट आई है, एंड टू बी ऑनेस्ट अभी तक 89.5 को किसी ने चैलेंज नहीं करा. सिंस यू हैव टोल्ड दिस टू मी, वी कैन टेक अप दिस इशू बिफोर द हाई कोर्ट. सिमिलर इशू अगर देखा जाए तो रूल 42 में भी आता है, जो आपने बात बोली है, रूल 42 ऑलरेडी चैलेंज है हाई कोर्ट के अंदर विद रिगार्ड टू रिवर्सल ऑफ आईटीसी.
सर इसमें बहुत फर्क पड़ रहा है जी पार्टीज को, हमें ये करना पड़ रहा है कि वी आर आस्किंग देम नॉट टू डू ट्रेडिंग.
People will connect personally on that. I think a lot of people are
okay जी.
ठीक है.
Thank you sir.
जी गौरव जी आपकी आवाज नहीं आ रही है.
सर सुरेंद्र पाल जी का नेक्स्ट है
जी.
सर प्लीज मेक इट फास्ट. सुरेंद्र जी.
हेलो.
हाँ जी पूछिए सर, पूछिए. यू आर ऑडिबल.
नमस्कार सर.
नमस्कार जी, बोलिए सर.
सर मेरे की पार्टी का ना सर रजिस्ट्रेशन मैंने रजिस्ट्रेशन कैंसिलेशन कर रखा है, लेकिन सर डिपार्टमेंट कर नहीं रहा सर. उसमें ना मिसमैच का इशू आ रहा है. जो कुछ सप्लायर सर फ्रॉड थे सर, उन्होंने ना मतलब वो कह रहे कि फ्रॉड पार्टीज हैं, बट हमने जेन्युइन माल लिया है सर उनसे.
सुरेश जी, तो सुरेंद्र जी, तो बड़ा फैक्चुअल एस्पेक्ट हो गया सर. अगर वो कुछ कहते हैं और आप कह रहे हो आपका केस ठीक है, तो आप रेलेवेंट एविडेंस फाइल करिए, उसके पास रिप्लाई फाइल करिए. ही विल कंसीडर इन केस ही पासेस अ रॉन्ग ऑर्डर, यू कैन गो इन अपील.
सर उन्होंने मुझे ना 2-3 बार ये शो कॉज नोटिस भी दिया है, समन भी दिया है, लेकिन उसके बाद हम दोबारा गए नहीं. उनके बाद ना वो
आप नहीं जाओगे तो सर फिर तो उनको तो फायदा ही है ना सर.
सर एक्चुअली परेशान कर रहे हैं सर, कह रहे हैं टैक्स पे करो सर. टैक्स सर 2-3 करोड़ की अमाउंट है.
कोई बात आपसे, अगर आप वहां पर जाते हैं आपकी जेब से जबरदस्ती से पैसे तो निकलवा लेंगे ना. आप उनकी बात को मानोगे तभी निकलवाएंगे ना. आप चले जाओ उनके ऊपर. अगर कोई आपके ऊपर जबरदस्ती करता है आप बता देना, हम पुलिस में रिपोर्ट करवा देंगे सर उसकी.
ठीक है सर.
ठीक है सुरेंद्र जी.
अनुराग जी.
गुड आफ्टरनून सर.
जी अनुराग जी बोलिए सर.
सर अब जैसे ना इन्होंने एक 13 जुलाई को नोटिफिकेशन इशू की, जैसे उसमें जैसे कुछ आइटम्स पे जो इन्वर्टेड ड्यूटी का रिफंड है वो बंद कर दिया.
जी जी.
जैसे ऑयल इंडस्ट्री का था या और कोक इंडस्ट्री का था. तो उसके बाद इन्होंने ना एक सर्कुलर निकाला 10 नवंबर 2022 को. तो उसमें इन्होंने ये कह दिया कि जो 18 जुलाई से के बाद एप्लीकेशंस फाइल होंगे, चाहे वो किसी भी पीरियड को पर्टेन करती हूँ, उस पे नई नोटिफिकेशन लगेगी. जो 18 जुलाई से पहले एप्लीकेशंस फाइल हुई हैं उनके रिफंड दे देंगे. अब जिन एप्लीकेशंस का भी 18 जुलाई को 2 साल का टाइम एक्सपायर ही नहीं हुआ था, तो उसको भी ये डिनाई कर रहे हैं।
सर सर्कुलर इज बैड, सिंपल आंसर इज सर्कुलर इज बैड सर। आपने जो बात कही है बिल्कुल ठीक है, 18 जुलाई तक का रिफंड सबको मिलेगा।
वो तो वेस्टेड राइट है ना हमारा।
बिल्कुल ठीक है सर, 100%। वो जो इन्होंने प्रोविजन बनाया वो रेट्रोस्पेक्टिव थोड़ी है। एवरी प्रोविजन अनलेस इट इज स्पेसिफिकली मेड रेट्रोस्पेक्टिव इट हैज टू बी कंसीडर्ड एज प्रोस्पेक्टिव सर।
तो उसको हाई कोर्ट में रिट करनी पड़ेगी, है ना?
जी सर, एब्सोल्युटली।
नेक्स्ट
Thank you, sir.
जजमीत जी।
नमस्कार सर।
जी जगमीत जी।
सर एक फेसबुक की सर्विस यूज करता था 2017 में एक पर्सन, पर उसका जो काम है सारा ऑनलाइन था। चाइना से मटेरियल लेता था और अमेरिका में सेल होता था। ड्रॉप शिपिंग उसको कहते हैं हम बिजनेस में। तो इंडिया में कोई उसका बिजनेस नहीं था। 17-18 में उसका 18 स्टार्टिंग में उसका काम बंद हो गया। उसके बाद कोई ट्रांजेक्शन नहीं हुई। 2019 में नोटिस आता है उसको फेसबुक सर्विस यूज करिए उसका आरसीएम पे करने के लिए।
जी जी बिल्कुल ठीक है सर।
वो नोटिस के अगेंस्ट हम इंटेलिजेंस दिल्ली से आया था नोटिस उनको।
जी 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 जी
सीनियर इंटेलिजेंस ऑफिसर डीजीआई हेडक्वार्टर दिल्ली से।
जी ठीक कह
तो
रहे हैं।
उसके रिगार्डिंग वो उसने वही जो असेसी है वो वही कह रहा है कि मैंने इंडिया में कोई सर्विस तो नहीं करी, पर मैं इसके रिगार्डिंग क्या सर्विस टैक्स
सर
पे
इसके
करूं।
लिए स्पेसिफिक प्रोविजन है। आकृति कैन यू टेल मी दैट प्रोविजन, वो जौन सा था OICAS करके एक स्पेसिफिक प्रोविजन है which deals with such particular situation where a person has this
ऑनलाइन इंफॉर्मेशन एंड डाटा
absolutely
हाँ जी हाँ जी
absolutely
सर।
OIDR सर, उसमें
OIDR
आपको रिवर्स चार्ज मैकेनिज्म में टैक्स लगेगा सर उसके ऊपर।
लगेगा
सर अशोक सर उसमें टैक्स लगेगा सर। यू हैव टू पे अंडर द आरसीएम ऑन दैट बिकॉज़ यू आर द रिप्रेजेंटेटिव ऑफ दोज पर्संस इन इंडिया।
ओके ठीक है सर, थैंक यू सर।
नेक्स्ट सर अरमान कालिया जी का एक क्वेश्चन है सर Q&A में।
जी
GST cancellation request was filed in the month of May and GST number is suspended since Since then, no show cause notice is issued or cancellation order is passed. Application is still pending for processing. It is a common.
Sir, this is very common, but there is a provision under the law that they have to decide this within 90 days, sir. They have to do it.
अरमान जी पूछना चाहते हैं तो पूछिए प्लीज सर। अरमान जी हाँ जी अरमान जी पूछिए, यू आर ऑडिबल।
Yes, sir. Sir, do I do anything about this? Because I communicated with them on a telephonic conversation. They said you need to meet the GST officer to proceed further by a physical meet.
Sir, I think you can go and meet the officer. He should do the needful because it's a cancellation request on your voluntary you want to get it done in voluntarily, so therefore there should not be any problem. But in case he's not doing this, then you have to approach the High Court again seeking mandamus. That is it.
मैं थोड़ा सा इसमें ऐड करूंगा, बिफोर यू गो टू हाई कोर्ट एक एविडेंस क्रिएट कर ले, फोन पे ना बात करें, उसको मेल डाले, राइटिंग कर ले, एविडेंस दो क्रिएट कर ले, तब संदीप जी की सर।
मैं वही कह रहा हूँ सर, मैंडेमस सीक करने से पहले आपको एक राइटिंग में की रिमाइंडर देना पड़ेगा उनको दैट यू हैव टू कंप्लाई विद सो एंड सो लॉ प्लीज। ऑफ कोर्स कोई भी मैंडेमस हम ओरली नहीं कर सकते हैं सर, पॉसिबल ही नहीं है होता।
सर चैट में सुशांत गुप्ता जी का क्वेश्चन आया हुआ है बड़ी देर से। इन वन ऑफ आवर केस GST and cancelled for non-updation of bank account details, जो आजकल नॉर्मल सर नोटिस भी आ रहे हैं। Now current account can't be opened since GST and is not active. Matter is time barred in appeal. Any relief or suggestion? सुशांत गुप्ता जी का क्वेश्चन।
सर अगर आपका टाइम पार हो गया तो उसके लिए आपको वो मद्रास हाई कोर्ट की जजमेंट का बेसिस लेते हुए हाई कोर्ट ही अप्रोच करना पड़ेगा, सगुना कट पीस की बेसिस के ऊपर। दैट वी हैव ऑलरेडी डिस्कस्ड इन एलैबोरेट।
मैंने बोला और नहीं
जी
ठीक है सर।
चले सर, आपा शुड वी गो टू द नेक्स्ट टॉपिक या फिर?
श्योर सर। एक सर ऋषभ गुप्ता जी का लास्ट क्वेश्चन है सर DRC 03 के लिए। ऋषभ जी पूछना चाहते हैं कि बाद में ले सर? ऋषभ जी पूछिए प्लीज।
ऋषभ जी जो आपका क्वेश्चन है वो कह रहा है कि DRC 03 के थ्रू जो पेमेंट करी है for the case in which you have succeeded in appeal, whether you will get interest on that. So he would get interest on that, sir. Of course, he'll get whatever amount has been paid by him in excess, that he'll get whenever he'll get the refund, he'll get interest on that. Of course, as per the provisions of section 50 from, the date would be relevant from which date it is to be paid.
All right, sir. I think we should move ahead, sir.
Right. So friends, going further, I have very small time left now to discuss the issues of real estate and construction. I'll just run through that. There are 3-4 issues which we can discuss. One is with regard to the fact whether, as per terms of this notification, the tax can be imposed on the real estate cases by deeming it to be, the valuation be deeming to it to be 2/3 of the total construction value, of the total value which you receive from the buyer. So when you are receiving the value from the buyer, they are presuming that in every single case across the country, the tax would be payable at the rate of %. By saying 18%, then it would be like 2/3 would be the valuation, which the Gujarat High Court has very recently considered in the case of Munjal Manish Bhai Bhatt versus Union of India, where they said you cannot presume the value of construction in a given contract because it will vary from place to place. Similar litigation we had fought under the VAT also before the High Court in CHT developers, where the court had again stated that you can impose the tax on the value of the goods which are transferred in a case of real estate project. And here also they can impose the tax on the value of the goods and services which are other than immovable property. So how do we find out the value of that immovable property? By way of notification, they are saying the rate of tax will be 12%, which is not correct in the eyes of law, and that provision has been struck down by the Honorable Gujarat High Court, where they are presuming it to be taxable at a fixed rate, by valuing it at a fixed rate. Then second aspect जो recently arise हो रहा है in the case of real estate, that is with regard to the cancellation, refund on the cancellation of flats. Suppose a person has booked a flat, he has paid the entire amount of GST on that, because in certain states the possession and everything is given even before the full payment is made, and thereafter the cancellation of that flat takes place. For whatever reason, he is not able to make the full payment, and that cancellation takes place, the developer says, I've already paid this tax to the state authorities, to the revenue authorities, so I can't refund it back to you. And the buyer who has already paid lakhs of rupees, or maybe in certain cases more than crore of rupees, how should he get the refund? Now, as per law, in case a transaction gets cancelled, then the refund, this transaction is not leviable to tax in a case of B2C. And in that scenario, the refund has to be given to the person, and the developer can take credit of that amount in the next return which he is filing. But he is also right in a way that he has already paid this tax to the revenue authorities. So in that scenario, what he can do, he can request the department authorities to seek refund of that amount, or he can adjust the amount. Insofar as the buyer is concerned, he is very much entitled for seeking refund of that amount from the developer. The question which arises is, in certain cases, the cancellation takes place after the 2 years from the allotment of the flat. So there is one the AAR which says that in case the 2 years period has passed, the refund will not be given, because the date of the allotment of flat would be the relevant date for the purpose of section 54, which in my respectful submission is not correct. It would be the date of cancellation of the flat allotment, which would be the relevant date for the grant of refund, because the event has taken place thereafter. Of course, not to go into the question whether the charges which the developer has taken from the assessee, from the buyer, on account of cancellation charges, on that the GST is definitely payable, subject to the fact again that whether the penalty charges are amenable to taxation or not, because under the service tax there are judgments to that effect that it is not so payable. So that's a litigative issue, but for the remaining amount there should not be any dispute of seeking refund. Then the third aspect is on the question of common maintenance charges which are being charged by the developers from their residents. I had come across one case where the any amount which is in excess of 7,500, they are saying you are liable to pay tax irrespective of the fact whether it is being the society is made up of those residents or not. They have now, the AAR has stated that no taxes to be paid because you have hired certain persons from outside, though it is being provided by the Residents Welfare Society itself. So we are encountering all those negative ARs and negative orders from the authorities. But to my mind, common maintenance charges are not payable in a case where it is in excess of 7,500 also, but where it is being provided by the Residents Welfare Society for their mutual benefits. So that tax is not payable to that extent, but the authorities are still imposing the taxes. Then there are few things which are which fall under a little gray area, I would say, whether the developer has to charge GST on that, like preferential location charges, where it is a composite supply with the construction of a plot or for the flat, whether any different GST has to be charged or not. That, according to me, would fall under the composite supply and no tax should be charged. But the department is saying no, composite, wherever it is preferential location charges, tax has to be paid on that. Then car parking charges are to be charged, tax has to be charged or not. There are two ARs on that where they say it is taxes payable on that. IFMS is the security which is given on which no tax is payable. There should not be any dispute. Then there is interest on delayed payment, whether that will form part of transaction value or not. That is, as per section 15, does form part of the valuation. But according to me, again, that would be the part of the entire amount, the capital amount which is being paid, on which the GST should not be charged. Interest is not something on which the supply has been made. So these are the certain issues which we have quickly run through. Otherwise, we would have gone in detail on that. So is there any question we can take up that? So otherwise we can wind up.
Sir, so far as prime location charges are concerned, now the CBIC has come with a circular that this is like composite supply. And so far as mutualities of resident welfare societies concerned, I think the government has amended the law with retrospective effect to dispense with the mutuality condition in GST law.
Sir, mutuality, that's on a different aspect. जो आप mutuality वाली बात कर रहे हैं, वो तो उन्होंने remove कर दिया for the purpose of clubs. But for this purpose, the notification itself says that the Residents Welfare Society, wherever it is charging, they are not liable to pay the tax. So that's falls in a different category. We are presuming it is taxable, but there is exemption notification for that.
That is up to 7,500.
7,500 in any case is exempt. Beyond 7,500 also exempt in case it's a Residents Welfare Society.
Thank you, sir.
सर ऋषभ जी के काफी क्वेश्चन हैं चैट बॉक्स में. ऋषभ जी, पूछिए.
Gaurav ji, can we wind it up in 5-7 minutes because I have given time to somebody.
Okay, हाँ, sure sir, sure. मैं क्या शायद वाइंड अप हो गया आपने.
जी.
हेलो
सर, ये ईमेल वगैरह शेयर करने को कह रहे हैं, वो मैं शेयर करवा देता हूं.
हाँ जी. और सर कॉम्प्लीमेंट्स भी दे रहे हैं आपको. दैट इज अ वेरी गुड सेशन
जी.
जेश टोटेजा जी और
थैंक यू सो मच.
आप लोग लिख रहे हैं उसमें.
सब लोगों से सीखने को मिलता है, सब लोगों से बात करते हैं, कुछ ना कुछ जरूर सीखने को मिलता है.
और ईमेल आईडी और फोन नंबर सर पोस्ट कर दीजिएगा.
आकृति, प्लीज कैन यू डू दैट?
एंड I think, sir, if you want to go, can we wind up the things with?
चलिए.
जी आप कर दीजिए सर, फिर मैं बत्रा जी को रिक्वेस्ट करूंगा 2 लाइन सर, अगर आप कुछ भी कंक्लूड करना चाहें.
नहीं, थैंक यू सो मच जी. थैंक यू फॉर गिविंग मी दिस अपॉर्चुनिटी. आई एम रियली ग्रेटफुल टू अशोक बत्रा जी. इनकी किताब पढ़ के तो हम लोग जीएसटी सीख रहे हैं और सर्विस टैक्स में जब भी लिटिगेशन कोई होती है तो इनकी किताब देख के हम लोगों ने मार्क करके आगे बढ़े हैं. तो इनकी गाइडेंस हमारे साथ हमेशा रही है सर. Thank you so much. He had been very kind enough to be here and to bless us. Thank you so much, all of you. And we look forward to...
I intend to listen to you from 4 itself. But again, some professional commitment. So I was free just now, so I thought I must join now.
I totally agree, sir.
It is my place. It is my place.
My pleasure, sir. My honor, sir. Thank you so much, Gaurav ji. Thank you so much. Thank you, Piyush ji. And
thank you so much, sir,
for having invited me.
The chat box itself shows how dedicated you have handled the session.
Thank you, sir.
Your crystal clear information on every aspect is very useful to all the attendees, sir. Moreover, you have quoted so much cases which have been very useful for everyone. To the point things, sir. My best wishes to you, sir, and request also to you to please be available for this platform of book and the Chartered Accountant Association. My humble thanks to Batraji also, who always tries to bless us with his valuable time, sir. And others also, many senior members have joined us like Atul Puriji, Vipul Aroraji. My heartiest thanks to all for sparing their time and joining us in good numbers. Thank you so much, sir. Thank you.
Thank you, sir. Thank you, sir.
Stay tuned with us for the next sessions also. Thank you so much. Thank you, Batraji. Thank you so much. Thank you, Sandeep ji. Thanks to all.
जो थोड़ा टाइम में देखना किसे होना चाहिए जी काट लिया उन्होंने